If it is, take back the copy, affirm it and then come. Yes.
Mentioning relating to the school, where the president is not this is affirmed, result of which we and other things are all installed. That means the situation Lordship was kind enough to allow this matter and to direct my Lord listed in the bill. It was not listed because our fault also because record was expired. Now my Lord it is listed item number 249. Only difficulty my Lord 2,500 students or the non-cooperation of the president who happens to be my Lord a very influential person of the locality. Well, the school authority is not going to sit and my Lord to pass on all other things. That shall not that being the situation.
So what is to be done? You see the condition of the list.
It's going to be suffered.
Yes.
A small mallet done 5-10 minutes is required.
5-10 minutes. I am here every day.
True, but the things you kindly consider the plight of the student. Midday meal is essential for the village person is concerned. And
15th it will appear. 15th.
May I permit it to mention?
SSC matter, madam. Running in the monthly stats, item serial number 1667.
What is the issue?
We are the state aided college teachers.
See, the issue is pending consideration. Whatever order is passed will cover you. Do not worry about that. Just wait and watch what happens.
In the head of SSC.
All right, give the number SLST.
May I permit?
In preliminary interview list, my name featured a serial number 8. I secured 71 marks, 10 marks for prior. Now they have published a list from 2nd December to 2025, disqualifying me, reducing my prior experience to 0 miles. I have already annexed everything. Well, I have made objection on the same date. Until unless the matter is not adopted,
It cannot be helped, sir. It just cannot be helped. I understand, but the way it doesn't matter. The main issue is pending consideration. Or
I mentioned the same in the application.
Despite awarding after credential verification, if they get to see that you are not entitled to the marks, they are taking it away. So it cannot be said that they are doing anything wrong. Nothing. File it in the department. Yes, sir.
Was a teacher of RB Public School. He worked for 2 contracts.
What do you want?
The inclusion of the matter.
Inclusion, no inclusion.
I'm praying leave move a matter upon urgent basis. The petitioner had
Where is the matter?
My lord,
You want leave?
yes, my lord.
Why?
The petitioners, my lord, had applied in a second SLST exam under my lord SC/ST category, but their category has been wrongly updated into general one. The verification process is going on, and some of them, my lord, maybe matches the cutoff of the verification. They'll be highly prejudiced, my lord, and the court has passed the identical order regarding such, my lord.
All right.
Grateful, my lord.
Tuesday.
Here, my lord.
Is it an affirmed copy?
My lord.
Here, my lord, I have also same matter, but my lord, it is Jalpaiguri bench, my lord, circuit bench.
Go to Jalpaiguri.
My
Bench
lord,
is not there.
no, my lord. Now the bench is not there. May I have a leave, my lord? I'm my lord,
When will
fully
the,
covered by your lordship order.
when next week also the bench will not be there?
My lord.
In that case, Tuesday. Leave দিতে হবে. This is a Jalpaiguri matter.
Yeah, affirm করে আনবো।
Is it not affirmed?
I will come back with that.
Yes.
Malad, may I permit to mention monthly list 1560 for upgradation. That is in respect of die in harness petition. Malad.
Died in harness, what you want?
Malad, for the order passed by the DI, that against that the deed has been filed. Only for upgradation.
Challenging what?
Challenging the order of DI for rejection of my
Claim.
candidature.
Claim for what?
For my, that is in respect of die in harness. My application has been rejected by the.
Pension, retirement dues, compassionate appointment.
No.
Many things. What?
Compassionate count.
Compassionate
Compassionate count.
appointment.
Yes.
It has been rejected.
Yes.
Please wait. No upgradation.
May I permit it to mention for correction or
Correction?
Yes.
What?
order?
What is the correction? Yes, madam.
Updation, Lordship.
Why?
Second SLST matter, question dispute matter, Lordship. Similar matter already running in the list, Lordship.
Already running. Second SLST bundle দিয়ে দেবেন তো. Give the number.
or 9/2024 order has been passed by the lordship. This order lordship.
Well, I do not want to see. What you want, you say.
Direct the Panchayat lordship to construct the solution.
What you want, madam, please say.
Panchayat did not come.
Yes, what can be done? Yes, please say, make your submission. What you want? Contempt you have filed. Yes, it will appear. Do not mention. Yes, sir. No inclusion, sir.
Monthly list.
Why?
Because matter is very urgent. It is about wrongful evaluation by TBS. And petitioner prayed for implementation of our latest 2025 decision passed by Honorable Supreme Court, which allows exposure of other candidates' marks. Petitioner only seeks enforcement of his classmates' marks, so that to ascertain whether there has been a fair evaluation.
All right. There is no urgency to
It is job interview.
let him appear. It is his marks. He will not see how much others have got for the other job interviews. I will see what is to be done. Not now.
Should be permitted to mention for upgradation in this matter. This matter is appearing in the monthly list of December 1152. And this matter is about to, in this petitioners, prayed for release the retired due. And lastly, this matter was appeared in the 2nd of May. And after that, it is not coming up in the list.
Please wait. Yes.
Lordship, in para 4, it was written typography written. It was a preliminary interview. The documents verification is under process.
I cannot hear you. The
Due to some typographical error,
what is the typographical error?
it was written in the order that is preliminary interview. My prayer is that documents verification is under process, my lord. So for that it was.
Give it for check it up. If there is any error, then put it in the correction head.
Grateful, my.
Your name is not there. When is the matter appearing in next? Fixed on? It's not there in the order? It must be there when it is returnable. If it is there, the returnable date, then last, you do not.
The petition has been dismissed, disposed of.
Oh, it has been disposed of. Dismissed. Take their appearances have not gone down.
There was an order which had been
Original site
passed in August, asking us to reconsider, we are the insurance company, reconsider such representation. We had filed an application for modification of that order. Dismissed that modification application, but indicated that all matters are open for the insurance company to consider when the representations are being considered. Now we have given them, thereafter we have given them notice to appear for hearing. Prior to the date of hearing, that which was yesterday, they did not appear. They have been issuing us letters after letter for content.
What you want the court to do?
It's a disposed of proceeding.
What you want the court to do?
Is that continuously we are being sent notices with regard to contempt.
So what?
Well, because they have not complied with the order. Lordship passed an order in August. Lordship asked them to give a hearing.
Call the list, please. I'm
Great,
not hearing
great.
anything.
Yes, Miller want with liberty, to move afresh on
Why?
updated course of action.
2017 matter, now you want
It was
non-prosecution.
happened only there was direction for affidavits. What happened?
Yes.
This is regarding my lord, the approval of appointment of the petitioner in the post of computer teacher. Now, my lord, this matter was moved, my lord, not from our chamber. Now, my lord, subsequently, there are several schemes has been laid down by the district inspector of schools for some giving benefits to the computer teachers. Now, the petitioner's appointment was not again a sanctioned post. So that is why he wants to withdraw this writ petition with better particulars for that scheme, for getting benefit of the scheme under the
Then
tier
what is
school.
the use of granting leave? If you don't want to press, don't press. If you got a fresh cause of action, file a fresh
Yes,
petition.
with liberty to move on fresh cause of action. Justice kindly
That liberty is not required.
not
You
required. As
are
you-
always free to come up
original,
with.
with
Please
the
come.
original.
Pradeep, not press. Please pass orders.
Sure.
And the written communication, if there is any, please keep it.
There was no interim order.
Yes. Correction.
Milord,
Last
what?
name,
Milord, liberty to move for a fresh cause of action, if that is added, Milord. Milord, we do not know once a petition is moved, then again a petition may be on other cause of action. So, Milord, a different cause of action we shall move.
Different cause of action. Why is leave required, you say?
Milord, nowadays so many embargoes are only
There's a different cause of action.
yes, is kindly mention if anything of these. That means the equal pay for equal work prayer is also here. If we have to add this below, that is why. Is kindly add.
Leave is required only if the self-same cause of action is there. If there is a fresh cause of action, there is no leave required.
Under the scheme, but if we pray for the equal pray for equal work, which is also prayer in this writ petition. So, Miller coupled with 2-3 prayers. So, if one prayer is covered by this writ, Miller
Yes.
Miller liberty, Miller losses kindly give.
Let me see your letter. The notice the not press. Kochiki. What letter has your client given you? How you have advised your client, I do not know. I don't want to proceed for my personal difficulty.
Yes, my lord. Thereafter, now prayed for liberty. To
That you have added.
No, not added. My lord, that was our advice that if we want to,
So that means you are not giving proper advice to your client. If you have got at least a part cause of action there, then you can proceed with the matter. You can fresh cause of action. You can file fresh petition. Why you want the whole thing pending from 23? It's at a matured stage. You want this to be withdrawn, go back afresh to square one, and then you start. I cannot follow. So leave I cannot grant. If there is fresh cause of action, it's all right. Item 2, what is the correction?
But in this matter, my lord, the objection was made only to in the Siliguri matter, my lord.
Oh, this is a matter of Kuch Bihar.
Kuch Bihar, my lord.
How can this be taken up here?
My lord, liberty to move this bench.
Send it.
My lord.
এটা কি ঝামেলা আছে?
It is
You
send
can
it.
send it.
My lord.
It will be renumbered and it will go.
Or he can file a press petition.
Party right.
Correction. Item 3, what is the correction? Item number 3. Somebody's appearance has not gone down or what? Why is it appearing for correction?
My lord, the petitioner's name spelling has been wrongly written.
Spelling wrongly written.
My lord.
What should be the spelling? Shaptorshi.
My lord,
H?
S-I. Yes, my lord.
An H has come. Shaptorshi. SH. H টা বাদ যাবে. Yes, next.
My lord. My lord, for the petitioner, in second point, my lord, instead of West Bengal Board of Secondary Education, it would be Central Board of Secondary Education.
Second
Second point, my lord.
Second point.
Second para.
Second para.
Item 4, my lord.
Yes, Central Board of Secondary Education.
Yes, my lord. It would be, my lord, Central Board of Secondary Education, and here it is stated West Bengal Board of Secondary Education.
কোথায় ওয়েস্ট বেঙ্গল পাচ্ছে উল্টোপাল্টা আমাকে দিয়ে দেয়নি তো সেন্ট্রাল বোর্ড অফ সেকেন্ডারি লেখা ছিল show me the order sheet
My lord, from বোধিসত্ত্ব সিনহা।
Second December order.
order date
2nd December. No, 25 November.
it has been disposed of on 2nd of December proper date proper order is recorded
তার আগের দিন
My lord, pass it over, my lord, or
no I have followed it করে দেবেন বলা যায় না হয়তো চেইন অর্ডারের জন্য ডাকতে পারে করে দিন অলরাইট উইল ডু ইট
grateful, my lord.
but the final order of disposal it is written Central Board of Secondary Education then why do you want the correction
My lord, my senior instructed me by giving this order. Grateful.
All right.
I'm sorry, my lord.
Well, I'm appearing for the petitioner.
yes
The diary in harness
yes
matter, mother. The mother, once I moved the writ petition before this honor board earlier then, and Rajshekhar Manta, Malayalam Justice Rajshekhar Manta passed an order directed to Sogoto passed an order to consider. Now, after that order, they have considered this, kindly rejected this, kindly come to
page 35
page 35.
11 page only pension matter
Well, pension calculated and the group D's
high
the last line manner it is clearly evident that the petitioner initial pension for a full month
state are you ready with instruction
no my lord's order is there on the same line
no
they
no
my lord order is there on the same line
my lord, no instruction is required in this case. Kindly see, my lord, first page 34
yes
earlier page
yes
and kindly see, my lord, this circular they have mentioned in the second paragraph, last line, GO number 697 ES/S/IS 1808 dated 9th July 2009. My lord, kindly come, your lordship's order I have collected. Your lordship has
dealt with
elaborately in a matter. Kindly come to page 25. Kindly come to page 25.
yes
The last line, your lordship, kindly see. Page 25, last line.
697
Yes. This circular your lordship already dealt with earlier.
only page
And your lordship has passed an elaborate judgment on this issue. They are saying that they salary, income, pension is more than the D group.
but your lordship order is pension cannot take
Your lordship has already considered everything and passed a reasoned judgment. If your
similar order
your lordship kindly come to page 31.
yes 31
Yes, kindly see the second para. Nobody will be prejudiced. The matter is remanded back to the district.
all right I followed it the state government what is your submission
My lord, we have not received any instructions as yet. My lord, if it is remanded back to the district inspector of schools to be considered, my lord, it may be, I leave it to my lord.
the state government has come up with a notification where the upper limit has been increased. If that be so, then maybe the petitioners will get a chance. Where is that notification?
That notification, my lord, if my lord kindly allows me some time, I can get the notification.
Please get it because if it can be seen that the threshold level is increased, then it can be done.
Only 2,000 rupees difference.
এই আমাদের একটা ছিল না নোটিফিকেশন এখানে লাস্ট উইকেতে ইট ওয়াজ ইউজড দি
আর জজের জাজমেন্টই বড়।
দি লেভেল অফ কি বলে পেনশন for consideration of group D appointments. This has been threshold as you get hold of that notification. When are you coming next?
My lord, next Wednesday or Monday?
No, জজে থাকবেন না।
Monday?
No, Monday is 8th. He will not be able to collect it on Monday. Then 10th,
We should
Wednesday, by 10th. And Thursday, it's impossible.
আরে ওয়েডনেসডে থাক।
10th is Wednesday. Come on Wednesday and see the page 25 to 31. 697 has been considered.
Yes.
Come prepared. Liken in that order. The prayer of the petitioner for compassionate appointment stood rejected by the District Inspector of Schools, Secondary Education, Murshidabad. Stop. The same is impugned herein. Stop. Learned advocate representing the state is directed to come ready with updated instruction in the matter. Released on 10th. Two things, the government memo and the judgment that is there. Yes, next.
Number 8.
Well, I am for the petition, ma'am. Well, matters relate to the higher scale of pay. I was appointed in 2007 as honors postgraduate category. Thereafter, after taking the permission from the district inspector of school, I enhanced my qualification in 2021. Thereafter, I made requisition to the DI for granting the higher scale of pay. That was rejected, my lords, on the ground that though I appointed as a normal section, and due to the amendment of 2016, my lord, the Control Expenditure Act, I am not entitled to get the higher scale of pay. Last occasion, my lords, I handed over a judgment, my lords, where the same facts was deals with by the
7th January 25.
Yes, my lord.
The Manoj has that is page 32.
Due to amendment in the
The
control of expenditure,
that 14 was substituted in 2015, and there is a Malota two. There are two aspects has been Malota incorporated. In case of Malota junior high and Malota up to class 9, 10, only graduate is scale of pay is Malota permissible. And in case of Malota 11, 12, postgraduate scale of pay is permissible. Malota only one thing, some of the undisputed fact, just I want to point out to the leadership. Malota, if Malota is fairly considered, that very first page, page 70.
17.
yes,
Page 17 is the recommendation. Malota, she was appointed in honors PG, Malota physics, 2007. And if Malota will kindly come to, she had improved her qualification.
2021.
Appearing as page 28, the MSc Part 1 examination result was published on 17th June 2021.
listen, there is an order which the petitioner relies upon, that 7th January order. Will the petitioner be covered by this?
Malota, as the larger bench, the issue that Malota on acquisition of higher qualification, the Malota, the entitlement of higher pay scale is automatic or not. Larger bench has considered that issue.
Yes.
Malota, the reference that has been answered, if Malota will consider. kindly consider,
Which paragraph?
first, the very first, page number 5.
See, I have got a different judgment over here. If you can show me. Paragraph?
Page number 5, paragraph 2, the reference, the first reference.
Yes, whether in view.
Yes, whether in view of the fact that acquisition of higher qualification or qualification during the service career of an individual is right, and the same acts as an incentive to career advancement as well as acquiring a higher status of academic brilliance. Can such a person be forced to stagnate on a lower status perennially and forced to continue to work on a lower scale of pay which is not commensurate with the higher qualification acquired subsequent to his appointment? The answer to that reference, if will consider just the page, last page,
Paragraph number,
page 115.
paragraph number 2.
Paragraph number 273.
Yes.
The very first reference has been answered.
Yes.
The enhancement of pay on acquisition of higher qualification between the service period depend upon the relevant rules operating at the time of acquisition of higher qualification and cannot be claimed as a matter of right in absence of rules. Therefore, my lord, the relevant point is acquisition. He acquired the qualification in 2020-2021 session. By that time, my lord, the relevant rule that is operating, that is 2016, and my lord, there is a change.
All right.
This is my humble sir.
Kindly see the larger bench.
1 minute. It has to be heard. It cannot be done in such a manner. Please come.
Kindly see the 184, my lord. 1 second.
The
Paragraph number 184, my lord.
petitioner seeks higher scale of pay. Stop. Reference has been made to the larger to the judgment passed by the larger bench in the matter of Utpal Kanti Koron and others versus State of West Bengal and others. Reported in 2024 SCC Online Cal 1274. Reliance has also been placed on the order dated 7th January 2025. Passed by this court in WPA 20130 of 21. Namta likhe neben. Stop. Learned advocate representing the state respondents opposes the prayer of the petitioner and submits that none of the aforesaid precedents can be made applicable in the case of the petitioner. Stop paragraph. The matter is required to be heard. You want to file opposition or it can be decided on the point of law?
Point of law.
Because nothing on facts. Right. List the matter for hearing in the combined monthly list of January 2026.
Well.
Take this back. Yes.
Number 9.
Lord, kindly keep this on Monday, my lord.
All right.
We are
Not today. Is this also a SLST matter? Put it in the SLST bundle.
other matters not connected. This is different.
May not be connected, but I'm
SLST.
trying to keep it in one head. Item 9, SLST to diye deben to. Huh? 10.
ये फिर इसका बोलना तो मैं तेरे को सब
Dr. Miller. But I am this today I shall conclude. I think this matter has got two chapters. First chapter is whether the rule is valid. If not wholly, then whether that clause 10% mark is valid. If it is valid, then second chapter, when the mark should be given and to whom it should be given, things like that. Therefore, I am on the question of validity. My own submission has been the test for determining arbitrariness is whether the statute or the rules has got nexus, giving 10 marks to the teachers of experience, has a nexus with the object of the rule. Namely, to find out
Elaborate submission
that is
in
my
this you
submission.
have made.
That I shall get, sorry, I
Yes.
shall show this provision supported by the judgments cited by my learned friend on the other side. So I am dealing with the judgment one by one. No. No, it will be apparent from their judgment cited that the government is the authority to frame any rules, to make legislation, and court will not sit in appeal. Yes. This will appear from their own judgments. Court is not appellate authority. Government is to frame the rule, presumption of validity. All appear from their judgment. Next, the criteria is reasonableness of determination, nexus with the object and purpose. Then, next is the marking system or the employment marking system is whether that is separable. I'll come to that later on. Whether this only that particular rule, schedule, if it can be cancelled, whether that is separable at all, or will that mean entire rule has to be cancelled? So may I continue dealing with the judgment cited by them? I have cited one judgment, or dealt with one judgment, that is 225(7) SCC. Now, if I may now deal with the next judgment cited by them, by Mr. Bhattacharya, 1995, Supplement 2, SCC 235. No. আমার কাছে কপি আছে বইটা পাঠ করে দাও আগে।
Doesn't matter. ছেড়ে দিন। Yes.
এখানে একদম সেকেন্ড got it? No.
Yes.
The learned friend relied upon one paragraph of the judgment. Please, without tell us what was the discrimination here, of course. Extra marks are provided for candidates for government office posts. It's not a teaching post, government office post, number one. Provided that he got his graduation through Telugu medium school. That was if a candidate graduation was the qualification mark, and the clause was if a graduate through the Telugu medium school, then he will get the extra mark, 5 marks extra. Government tried to support it by saying our object is to get the administration carried on in Telugu language. Supreme Court did not accept that, but that can be achieved. Proficiency in Telugu language does not mean that that boy has learned or got his graduation from Telugu medium only. Without being Telugu medium, could there are many persons proficient in Telugu language. And why it is not bad? This clause has no reasonable nexus with the object. That was the clause, Lordship, I in place, Lordship. Please come to paragraph 6, Lordship, get the subject matter of dispute. Paragraph 6, short paragraph, what was the dispute involved? What was the clause? Paragraph 6. And got it not?
Yes.
Starts like a few introductory facts leading to the promulgation of the aforesaid impugn rules pursuant to the impugn US government, on the section 6 provides, then the section about fourth line from the top of that section 7 provides for a special position to Urdu in addition to Telugu in certain areas of the state. Then section 8 confers powers to make rules for carrying out the purpose of the act. The government of Andhra Pradesh decided to introduce in stages Telugu as a language in administration. Then in 70, they think that the 70 government do this and in 1970, the government wrote to several other state governments to ascertain whether any weightage or preference was given to candidates who had studied in the respective regional language in the matter of recruitment of public posts. It is revealed from the record that the government of Kerala, Pondicherry, Tripura, Haryana, Goa, Daman Diu, Rajasthan, Kohima, Assam, Himachal Pradesh, West Bengal, Punjab, Gujarat, and Bihar had replied that no such preference or weightage was given in the process of recruitment. That weightage not regional language. Now, Lord, this is the thing. Please come to me, Lord. Paragraph 7. The special, then the government, by the government order, it was recommended that the governor on the Pradesh may make rule in exercise of powers under Article 309 of the Constitution and Section 8 of the Act to the effect that notwithstanding anything in Andhra Pradesh state and subordinate service rules or the special rules, candidates seeking appointment to the post in the service specified in the table appended to the rule, who had obtained the basic educational qualification prescribed for direct recruit in the special rules and governing such post through the Telugu medium. This was the challenge. Now, court is not accepting that. Okay, why not? Reason that's important. Kindly come to paragraph 13. They have referred to very long paragraph. But not may I request your Lordship, 13 starts. Please come to me, Lord. There's in the SSC page 243, paragraph 13 continues, so several pages. Please come to the page 243, the last paragraph. Supreme Court ratio that starts like aforesaid sub-classification. Yes. Aforesaid sub-classification of meritorious candidates into Telugu medium candidates and non-Telugu medium candidates, insofar as their graduation is concerned, does not have any rational nexus to the object sought to be achieved thereby. Then Supreme Court elaborate reasons were given why it has no nationality. Then it goes on, Supreme Court says that it has to be seen, then it continues, Supreme Court reasoning, several reasons have been given that it is, Telugu medium is appropriate at rural areas. Then it goes on, Supreme Court says, then can you turn the page, come to page 245. 245 bottom. For this reason, it must be held that the present rules of weightage to be given to candidates who have passed graduation in Telugu medium is violative of Article 14 and 16 of the Constitution and does not represent any valid and reasonable classification, having a rational nexus to the object sought to be achieved thereby. That I am relying on this judgment. And not in our case, our rules do not provide that he must have service experience in state government schools and colleges. Language only government colleges. Had it been only government, state government in West Bengal school and colleges, something would have been different. It's not so. So that's why this support has sustained me. There is no parochialism in this in our rules. It judgment supports my case. I rely on this. In support of the reason, lectures is the test. And our rules do not say that the testing experience must be gathered only through the state West Bengal government schools. Do not say that. Take a look, number 2. Next judgment, my lord. 2005, volume 13, Supreme Court cases, 721. Line 11, paragraph 11 and 12.
Two 2013.
2005, volume 13, Supreme Court cases, 721. That is by Mr. Bhattacharya. ওটা কোম্পানি নিয়ে থাকবে তো পেজ নম্বর আছে কিছু ওই বিনিয়োগটা ছিল মেয়েটি সব জানে
Is any of the petitioners present here?
এই তো কোম্পানি আচ্ছা ভাই কোম্পানি ওই সব জানে The name is Vinod Amita petitioner versus Union of India.
Yes, I have seen that judgment.
It's a case of a blind person.
All right.
The judgment of Justice Torun Chatterjee sitting in Supreme Court.
Yes.
Well, may I give you a copy for the time being?
All right.
Yes, oh, sorry, mark. Pencil mark. No, sorry, you know. I'm told it's a mark.
Matter, I'll return it to you. I have a copy, I can remember.
Pencil mark.
All right. No issues. It's all right.
But I tell you, without looking at the judgment, the fact is this.
Yes.
It was not teaching or school appointment, office appointment, number one. The bank appointment. Now, when the application was made, advertisement issued by the bank, this is the qualification eligibility criteria. It was not mentioned that blindness will be a disability factor. Or what was mentioned? A graduation degree and all that. This one blind person applied to the bank. And one line rejection came, we can I reject because you are a blind person that will not be suitable for our post. He applied to court. Ultimately, Supreme Court, she won. On what ground? The blind dismissed denial of right. What right was claiming? Not for appointment. You are claiming a right to sit in the written test examinations. Therefore, selection if is done in a written test, you are not allowed to have test. Supreme Court said, no, you cannot do that because in the advertisement you issued, inviting admission, you are nowhere stated that we shall not admit anybody having vision difficulty. Please see me, Lord, paragraph 12 of this judgment. It is one reason given.
Yes.
Paragraph 12. In our view and in view of the discussions made here earlier in the Faxon's case, Article 14 was infringed for denial of permission to the petitioner to sit and write the examination for selection of probationary officer. As noted here in earlier, this petitioner was not allowed to sit for the competitive examination for the post of bank probationary officer on the ground that she was a visually impaired candidate. Although the advertisement in the newspaper did not disclose that a visual impaired candidate cannot be allowed to sit and write the examination, as the nature and duty of the job were not suitable for the visually impaired candidate. It was not mentioned. It is not in dispute that each petitioner had qualified for the post of bank probation officer as per the advertisement. Statement has been made in the writ petition by the writ petitioner to effect the writ petitioner, like other visually impaired persons, can perfectly perform the job of a probationary officer. He also applied for the same post to BCRB and received her admit card for the same. Thus, there is a discrimination, responding between, etc. This is one ground. And not then another ground you have to find paragraph 11. Please come to paragraph 11, which is not I rely upon. Lot of things are said, equality. What is equality? So therefore, this case has no application, no relevancy, except without the legal principle laid down by Supreme Court in paragraph 11. What is equality? Paragraph 11. Taking our finding as mentioned to the extent that the petitioner was entitled to sit and write the examination for selection of probation officer in the bank, let us now proceed to consider whether writ petitioner would be entitled to appointment in the post of probation officer of the bank in question, if successful in the written examination, in view of the nature of the job to be performed as probation officer. Again, the nexus theory comes in. Whether this job can be performed by a person with a blind. Before we deal with the aspect of the matter, we may take into consideration yet another aspect of the matter, namely whether denial of permission to writ petitioner to sit and where the examination for the post of probation officer in the bank of his offense, Article 14 or 16 of the Constitution. This is the question. Article 14 of the Constitution guarantees to every citizen of India a right of equality before the law, or the equal protection of law. What does it mean? The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privilege in favor of any individual. Now, it also means, this is important, that among the equals, the law should be equal among the equal and should be equally administered, and that like should be treated alike. Thus, what it forbids is discrimination between persons who are substantially in similar circumstances or conditions. It does not forbid different treatment of unequals. Article 14 has both negative and positive. That's why I took the pain of submitting my lordship. Why these untainted candidates and the fresh applicants are not equals? I submitted that we have these unequals have already passed one selection test, and also served in there as a teacher, but they became subsequently discovered to be victim of circumstances. They are victim of circumstances. The other fresh people, they had not appeared in any selection test, had not passed any selection test. Our case is these unequals, untainted are already held to be competent to be teacher by competitive examination. Let the marking is also maybe. So, my lord, they should not be equals and unequals. And Supreme Court itself has made a different classification for untainted. Similar, they are not to be equal. Therefore, the rules, Article 14 is confined to treating equals are treated unequally. And also at the same time say, unequals cannot be treated equally. This is not equality principle. I rely upon the judgment for this proposition. And there are many judgments that Rashi is aware must be that unequal, if unequals are treated equally, then is validity of Article 14. But I did not cite because this judgment they have themselves cited. Next judgment cited is Supreme Court ultimately found on explained that probationary officer's job can be discharged by a person who is visually impaired. But Supreme Court said no. That allow her to cite in a written test, then proceed according to law. Yes. Now next judgment cited, my lord, is 2025 SCC online 1009.
Copy devo, sir.
Huh?
Hand over copy.
You'll be adding up copies. I want to see. It must be here. What is the name?
Samim Ahmed.
Sagid Ahmed. Yes, Ms. Sagid Ahmed will have this.
Give the citation once. 2025
2025
SCC online.
2025 2025 SCC online 1009. Name of the case is S. Ranjit Singh and others versus State of Tamil Nadu.
Yes.
Yes, Tamil Nadu. Yes, read some paragraph 19 relied upon.
Which page did you mention? Which page did you mention?
Page of SCC online is 1009.
All right. Yes.
If it's not easily traceable in the compendium, I can give a copy then.
No, you read, I can follow. You read, I can follow. No issues.
Yes.
No issues. You read, I follow.
Kindly see paragraph 6 of the judgment, which should have been placed. That will indicate the nature of controversy. Paragraph 6 at page. Notification is paragraph of page guno gelo. Notification korte. 6. This is without text of the case reveal that constables working in the police department in the year 1995 were given 20% of the vacancies to compete under the direct recruitment quota. And they were to be given seniority over and above the other 80% remaining constable recruited through open market. So, there are constables at a vacancy for constables. Now, out of that, 20% was taken out for allowing not the direct recruits. Direct recruits vacancy was 100%. Out of that, 20% being carved out for departmental candidates, already employed. Not only that, it also provided that departmental candidates who are successful, they will be placed in the seniority list over the new candidates, fresh candidates. That was a challenge. Seniority was being disputed. That will appear not paragraph 15. Supreme Court said what is the dispute involved. I beat paragraph, third paragraph, that page 9. The dispute involved in the present case is fixation of inter-C seniority in respect of direct recruitment, which includes some in-service candidates also. Sorry, sorry, I made a wrong reading and didn't comma full stop. Dispute involved in the present case is fixation of inter-C seniority in respect of direct recruitment, which includes some in-service candidates also recruited under direct recruitment quota. The 1955 rules provide the recruitment to the post of sub-inspectors of police by way of direct recruitment and by a promotion. Rule 3 quoted, etc. is quoted and going on. Then ultimately, my lord, the Supreme Court notes that the rule did not provide for giving such seniority. It was being done under executive order. Then government has been doing so for quite some time. Then government realized the mistake. It's a mistake. So they framed the rule, amended the rule with retrospective effect of 1955. And that was subject matter of challenge before Supreme Court. Then paragraph 16 I'm reading. The state government finally realizing its mistake issued GO number such and such on 21/11/2017, which is subject matter of the present appeals, reserving 20% of the vacancies for service police personnel and 80% vacancies for open market candidates for the post of sub-inspector police, and also for providing seniority to the in-service candidates en bloc over and above the candidates appointed in service by way of direct recruitment under 80% vacancy. This is the dispute. Now, what Supreme Court says, the reason that retrospective amendment with effect of 1955 is violative of Article 14. That is the first thing. Then next is when the Supreme Court, next down is that when you give those seniority, there's no rule permitting you to do that. But rule is contrary. And only relied on executive instruction. So question is whether executive instructions, orders, can supplant rules. That is paragraph 22, the main reasoning 22. It cannot supplant. Paragraph 22. Oh, sorry, may I read paragraph 19 also, that third line. Paragraph 19 Milord also. 19 Milord. That 19 it exactly responded. 19 Milord I'm omitting counsel's submission, I'm omitting. Then I'm reading in the last of that page, it is at page 19 of the SSC online. I'm reading the second part of this paragraph 19. In the opinion, in the considered opinion of this court, I'm reading that part. Such an action on the part of the respondent state is against the settled canon of law. The canon of law rule, that is Rule 25, was very clear, which provided for fixation of seniority with reference to the rank assigned by the appointing authority in the list of selected candidates. It is unfortunate that state government has amended Rule 25 by GO dated 21/11/2007 by giving a retrospective effect, that is with effect from 13 July 1995. That was given. The state government has certainly issued various executive directions from time to time for appointment under direct recruitment quota, providing reservation to in-service candidates to the extent of 20%. However, the rules were never amended until 21/11/2017. It is a well settled that proposition of law that executive instructions cannot supplant the statutory rules. This is my provision. they can supplement, clarify the statutory rules. In the present case, executive instructions issued from time to time have in fact supplanted the statutory rules, and such a process is unheard of in the field of service regulation. This is a point involved, which is not involved in our case. In this case, there is no such point involved. Executive instruction supplant, no. Therefore, it is not really relevant judgment to that extent. Then, that's an extent. If the judgment is quoted, I am not reading that. Then judgments are quoted in support of this proposition. Then paragraph 22 of the judgment. State government, without amending the recruitment rules, right from the 1955, continued with this appointing process under the direct recruitment category by appointing in-service candidates, and in the considered opinion of this court, such a recourse was not available to the state government without amending the recruitment rules. However, in the light of the facts that the persons have been promoted, this is not relevant for my lord in this case. However, that those appointments are bad, illegal. However, in the light of the fact that the persons have been promoted in 1995 and thereafter also, this court is not touching their promotion orders. The state government, without amending recruitment rules till to 2017, continued to appoint sub-inspectors of police from head constable serving the police department, and all such recruitments were made without amending the recruitment rules. The recruitment rules were amended only in the year 2017. In the considered opinion of this court, the amendment to the recruitment rules in the year 2017 is to the extent it provides for 20% reservation under the direct recruitment category, that category to the in-service candidate does not warrant any interference. Reservation cutting it, that it doesn't know, court did not interfere. However, the amendment brought by geo-dated 21/11/77, amending Rule 25A of the 1955 rules, which provide the grant of seniority to all in-service candidates over and above the candidates recruited from the open market, is certainly violative of Article 14 and 21 Constitution and deserve to be. Then retrospective effect is paragraph 20 deals with that. That is bad. Well, I am humbly pointing out these judgments, although the promotions or seniority given since 1955 up to 2017, illegal, contrary rules, the court did not interfere with that. Those promotees were not demoted. Maintain what has happened, because they are not, again, that this point comes here. The innocent parties should not be made to suffer. If they're party to the fraud, then that party should be made to suffer. Therefore, Supreme Court did not interfere with the promotions already granted. And the question of allowing 20% reservation, the rule was upheld, but not the retrospective effect. That is not. But although it did not do so, Supreme Court maintained the so-called, we call it illegality in the matter of promotion, because they have already been de facto appointed, serve in that post. That was not disturbed. Similarly, in this case also, Supreme Court took the similar view that those untendered candidates who passed the examination successfully, their service has to be terminated because of the genesis of illegal practice and cancelled. So, until the date of judgment of Supreme Court in Boishkali matter, their service was needed to be valid, and they were cancelled on the date of Boishkali judgment. And their service done for the period prior thereto has been recognized by the Supreme Court. They've been allowed to retain the benefit of the service and salary. They've been allowed to participate in the next election process, and they are allowed to have age relaxation. So, my lord, it is not at all correct in my submission when Lanetman says the appointments were void. No, the practice was void, null and void. But appointment given to the parties who were not party to the fraud, who are innocent, was not void. Secondly, my lord, I shall, so another point I'll take. So I should go this. So. But whatever teaching experience they gathered during the period of 7 years before the cancellation, that was gathered while their appointment was completed to be valid by Supreme Court. Is not teaching was gathered under a void appointment. In case of tainted, it was void because they are party to it. But therefore, if that teaching experience is honored, nothing wrong there. Next has been cited is 2005 SSC Online 2119. Oh, sorry, 2025, not 2007. 2025 SSC Online 2119. But it was tender matter.
Yes.
It was tender matter. Pay attention, sir. It says before Justice Sanjay Kumar, that's the बताया कि उसने गिरे जाते हैं. The other name doesn't matter. That it was tender matter. Tender grant of award has been considered to be a grant of largesse. But giving appointment to the teacher is not largesse. It is the right upon successful competition. Therefore, the principles of tender matters should not be applied when it's a case of appointment of teachers in competitive examination. This is number don't apply. Secondly, my lord, in tender matter, Article 19 is relevant. 119, yes, relevant. And that is the right to carry on business. That is not applicable in the matter of appointment of teachers. Article 16 is 16 applicable, not 19. Therefore, one may cite, let them, I don't object to that. But it is relevance smart. What was happening in this case? Condition number 4 of the tender condition was challenged, ultimately challenged. 4 conditions were challenged, but 3 of them were deleted by the tendering authority. Only condition of 4 remain. And what is condition number 4? My lord, find that in paragraph 8. Paragraph 8. During the pendency of repetition, corrigendum, later censors, 1, 11, and 12 were deleted. Division bench of the High Court by a common order dated 11 August, issued in civil matters, and by an order dated census, passed a repetition number up to, inter alia held that the impugned eligibility condition, namely condition number 4, with regard to past performance, is of similar nature and purpose as the condition in association of registration place versus Union of India. It was further held the respondent had demonstrated that the impugned tender condition is not unique into the state of Chhattisgarh, but a prevalent in the other states such as Gujarat, Assam, Delhi, Odisha, and Jharkhand. It was further found High Court a contract containing similar condition was awarded to appellant in the state of Jharkhand. Then High Court repealed the challenge to the impunity and the condition on the ground of discrimination and unreasonable. That was repealed by the High Court. Now, then submission of parties are noted that then analysis starts from paragraph 13. There the condition number 4 is quoted. Paragraph 13 quoted. Past performance on restriction. Bidders must have supplied sports goods worth at least rupees 6 crores to the state government agencies of Chhattisgarh in the last 3 financial years. Now, the Chief Minister of Supreme Court analysis that must have supplied sports goods worth rupees 6 crores. 6 crores, Supreme Court did not interpret. That is the wisdom. But to the state government agencies of the Chhattisgarh only, there the objection clinch. Then no nexus. Supreme Court says, yes, sports goods, object and purpose is to get good quality of goods. Therefore, you might have said 6 crores worth of goods, similar goods have been supplied. But why? If they supply to other states, that quality of maybe all right. Why you say that only those who have supplied goods to Chhattisgarh have supplied good quality? So that is, so confining this condition number 4 to Chhattisgarh was held to be have no nexus with the object of securing good quality goods. Similar. This confined was similar. That's why repeatedly I submitted, if the state government, in this case state, that the experience, teaching experience in state government school in West Bengal alone, then I would have said, why not? I might have acquired teaching experience from the other state governments, including central government. Question of experience can be gathered. But that is not done by, thankfully, they have not done it. And now
they have done this. No, they have.
They have. Yes. But rules do not say so.
Right. So you think, because I am having matters where this has been done.
They have done wrongly, my lord, therefore they cannot rely on that. But my lord, it is all settled. Next question. If a rule, if a law is wrongly interpreted and wrongly applied, does not affect the validity of the law.
In the application form that the candidates filled up, there was a column mentioned whether you have taught in government schools in the state of West Bengal. A specific column was there.
Yes.
It is there that the experience had to be mentioned.
Then there's that column should be bad. Not the rules.
পরে ডিভিশন বেঞ্চে এসএসসি বলেছে যে সবাইকে দেবে সাবমিশন বিফোর দ্য ডিভিশন বেঞ্চ
আচ্ছা এটা কি এটা কার জাজমেন্ট কোর্ট
এটা ডিভিশন বেঞ্চে এই ম্যাটারে অরুণিমার
but my learned junior points out, I'll come to that point. I first finish my first point. Wrong application of law. The format is fixed by the bureaucrats. Rule is framed by the government. If they've wrongly understood the rules and framed the format, that format is bad, but rule is not bad. That is Lordship knows, that is judgment to that effect. But Milord, if Milord, in the division when judgment was so mentioned, can we read paragraph 24?
So that means an occasion arose where this had to be brought to court. It is not that the rule is there, government, which includes state, central government also, and the authority acted. It is not that. Candidates had to approach court and obtain order.
Yes, therefore it was corrected. At the appropriate time before it started, corrected.
Anyway, you make your submission.
No, that's right.
Contrary submissions also.
The conduct may be bad. And Millard, paragraph 24 of revision when judgment reads like this. Is a Bandyopadhyay justified the awarding of 10 marks for prior teaching experience on the ground. It is also extended to teachers who are taught in schools under Kendriya Vidyalaya, Navodaya Vidyalaya Committee, State Council of Education Research and Training, etc. And other government-sponsored schools. Marks were provided with view to appointing teaching. So, but what the column may be there. But even then, the commission is making submission to court that this 10-mark teaching experience has been granted to those teachers who are taught in schools under Kendriya Vidyalaya, Sangathan Navodaya Vidyalaya Committee, State Council of Education Research and Training, and other government-sponsored schools. So that if the column is repeated, that is not being followed.
Yes.
That not followed. Now, Lordship is considering validity of a rule, legal validity of a rule, not on the rightful or correct interpretation made by the bureaucrats. If they're done, it has to be corrected. All those who have appointed with explanation made teaching experience in government school, they should be awarded. That can be corrected any time. And in fact, the government, when admits, even now I would say that whoever have teaching experience of the government schools, and not regardless of West Bengal or not, they will be awarded. They will be counted. That's enough. On that ground, rule cannot be violated. No, the judgment to that effect. দেখে দিও তো এখানে আর্টিকেল 13 violation হলে পর যদি wrong interpretation or bullying remark that it is held by the Supreme Court or not, that the actions done under a wrong understanding of a law does not invalidate the law. This is settled law. I think Mr. Dhar will cite judgment. I am not that is a settled piece of law. Now, Millard, kindly read paragraph 19 on which they relied upon. The paragraph 16 I am reading. Judgment also speaks of paragraph 16. What is level playing ground? What is paragraph 16? The principle of non-discrimination is embodied in Article 14 of the Constitution. Article 14 has to be read in conjunction with the rights conferred by the other articles like 21 of the Constitution. Article 21, etc. Constitution refers to right to life, equal opportunity as well. Doctrine of level playing field is an important concept while construing Article 19(1)(g), which is not available, in our case, of the Constitution of India, Article 19(1). Right. 19(1)(g) confers fundamental right to carry out business to a company. It is entitled to invoke the doctrine of level playing field, which is, however, subject to public interest. Number one, the doctrine of level playing field provides, it's important, the space within which equally placed competitors are allowed to bid. Equally placed, paragraph 11 of the earlier judgment Supreme Court. Equally, must be equally placed. Equally placed competitors are allowed to bid so as to serve larger public interest. This is without what is meant by equal level playing field is mentioned in this judgment. Then, in paragraph 19, the reason given why it is bad, which is read out, a reason not to find, object of public procurement is secure, this is I agree, object of public procurement is secure equality goods and services for the benefit of the public exchequer. Said object can be achieved by requiring the bidders to demonstrate financial capacity, technical experience, and past performance in contracts of similar nature regardless of the place of performance of the contract, to confine the eligibility to a participant to participate in the tender within one state is not only that irrational, but is also disproportionate to the goal of ensuring effective delivery. This again without nexus. Nexus. Confining that your performance, you must have supplied good only to the state of Chhattisgarh, and that's not good quality. It defeats it is disproportionate to the goal of ensuring effective delivery of sports kits. So disproportionate, it is do not achieve the purpose. Then no paragraph 20, if I very there one channel. Such a restriction, however, cannot be justified as reasonable with the meaning of Article 19(6) of the Constitution. State, while it enjoys the freedom to prescribe the conditions of the in the tender, cannot exercise that power in a manner that infringes upon constitutional guarantee by closing the market to outsiders without just cause. The doctrine of level playing field, again, requires that gates of the competition be open to all who are equally placed. That is mean, equally placed. Level playing field for whom? For the person equally placed. That a field may be given to others who are not equally placed. Now, in this case, Lord, it's a plus eligibility criteria. In our case, teaching experience is not eligibility criteria. Not eligibility criteria. So gates are open to all candidates. In this case, gates were closed for candidates who had not supplied goods to Chhattisgarh government. It is not the case that unless you have teaching experience in the school, etc., you cannot apply. You cannot apply. You know, sir. One with a full knowledge that if he does not have teaching experience in the government schools, he will not get 10 marks more. But in other 90 marks thing, he will get the full mark. Written test, academic qualification. You have taken the challenge. The freshers have taken the challenge. Best. Without 10 marks for teaching experience, we shall succeed. And I've shown to your Lordship, in a fact, 9,000, more than 9,000 freshers have been mentioned in the interview list. 9,000. And what is the vacancy there? 20,000, no? 20,000. I'm not sure. Maybe nearly 20,000.
No, 35,000. 35,000.
Oh, 35,000. 35,000. No, total 35,000. And untainted are 13,000 in all. So even if all the 13,000 become eligible for appointment, upon all marks being taken into account, they'll still have more than 20,000 nearly open for them, vacant, open for them. When Milot marks, the merit list will be published, it will not be confined to teaching experience. Written test marks, academic qualification mark, then lecture mark, lecture performance, and then teaching experience. So they took the challenge, and I support, and 9,000, more than 9,000 already included in it. So this is a case, and the midstream, they want to change the rule of the game. That is my humble objection. If selection process is cancelled, commission has nothing to lose. You'll again start the process, inviting tenders for supply of reels, tons of paper, inviting tenders for appointment of supplier of ink, the printing, etc. And huge could another, they will be placing the orders for what crores out there. They have nothing to suffer. But they'll again start a new selection process. And this time they may again contend This time the tainted people can also attend because second Supreme Court said not tainted to be allowed in second selection process. If I can have a third selection process, to that tainted will be also be allowed. And that question maybe days argument will go on. That point will go on for 5 years. Again, minimum 5 years. Again, go on. They have nothing to gain. But the commission's attitude, I do not know. But there's nothing to lose. But we have to fight for our own survival. That we have taken test twice already. Should I be subject to a third selection test? And that they have been teaching. So this judgment that I've drawn. The next judgment cited in 2011, 7 Supreme Court cases, 789, page 789. Here the question rule was seniority come merit basis. Some 50% was for only on merit, balance 50% seniority, merit come merit. Now the question arises, this is the question I also request also consider. Seniority, why that should be given weightage at all? Seniority means what? Experience, nothing else. Why that weightage being given while choosing a party with merits? So seniority, experience can be considered legally and lawfully in conjunction with the merit. Then written test, education qualification, etc. Therefore, no court has held that seniority is based on experience should not be, it is giving a wrongful advantage to the people who have served longer, who gathered experience. This principle of allowing seniority experience to be counted while deciding the selection on merit and selection shows me that experience has been considered and accepted as a relevant consideration in the matter of, say, for promotion. Then why not in the matter of appointment also? This is judgment law. This judgment I shall come to dealing with this judgment right now. This is 789, page 789. Paragraph 23. Page 50. Yeah? 50. Page 15, এটা ঠিক আছে বার করে I not got it.
Yes.
Yes, have been shown, that's why I'm reading it. Paragraph 23. The rule is set out in that in previous paragraph, wholly set out in the paragraph 18 of the judgment. But I'm coming to paragraph 23. Another very important aspect of the rule is that merit and seniority merit are the only relevant criteria for promotion to various posts. The language of Rule 24(1) or Rule 79 does not allow for any ambiguity and clearly says that a list of the senior most persons who are eligible and qualified under the rule will be prepared. And from that list, promotion on the basis of seniority come merit or on basis of merit, 50% on basis that was there, to the classes of post concerned will be made. Rule 24(6) of the Rules 79 further postulates that all other higher posts or higher categories of posts in the service shall be made on the basis of merit and on the basis of seniority, come merit, in the proportion of 50-50. 50-50. If upon if upon merit alone candidates are not available, then selection by promotion on the basis of selection come merit may also be made, the same man rule. So but if the balance 50, just 50% left for merit only, but then no candidates are available, then seniority rule can be applied also. What I'm humbly pointing out, my lord, the seniority, which is equivalent to experience, has been accepted by everybody as a relevant factor. Relevant factor is a, and so giving some credit for the experience is very reasonable and legal. But in this judgment, I don't cite it, the judgment support me. I do not know why. Anyway, I'm grateful on your side in that. His judgment also, my lord, same another thing, how schedule of a rule is to be read. Here, my lord, there are lot of argument on schedule of a rule on the interpretation. It comes. I'll deal with the paragraph 25-26. Since I'm reading the judgment, see, my lord, what is schedule? How to read a rule? How is schedule? Paragraph 25. The first and the foremost question that arises for consideration by this court is whether, merely by the amendment of Schedule 1 and the deletion of Schedule 2 of the rules, effect of the statutory provisions like Rule 6, 10, and 24, the substantive parts, etc., in other plain language, would then dilute it. Can it be argued that the amendment to the schedule then renders the statutory provisions ineffective and inoperative? Paragraph 26. It is settled principle of law that the schedule of the rules has to be in conformity with and is required to advance the object of the primary statutory provisions. Thus, a schedule cannot in any way wipe out the Statutory Provisions Act, and in effect, and the spirit, it is nobody's case, and in fact, nothing has been brought to our notice that Rule 6, 10, 11, 12, 14 of the rules have been subjected to any amendment by the competent authority. Once these provisions stand, etc. So, my humble servant also when it comes to interpretation, if the rule is held to be valid, then question arises whether it will be the teaching mark 10 will be given before interview or after interview schedule, etc. Then I shall similar their approach has been they have read the definition first and then the schedule. Then substantive part, not that. Similar my submission I'll say that later on. What is definition clause? It is dictionary for the expressions used in the substantive part of the rule. I'll cite show your lordship that. And schedule, what is that? Schedule is to advance the primary object of the rules. So schedule says in what order the marks will be given. And when I come to independent scholarship, schedule means in order marks to be given and teaching experience mark to be given when that is in total conformity with substantive part of a rule 11. So that is, it is admin also assist your lordship to say how schedule, what the effect of schedule. The next judgment is 2024 13 SCC 241. This judgment, I don't know why it is cited. Anyway, cited. It tells it is in paragraph 37 has been read. Yes, is less down when the rules can be said to be ultra vires is a parent act. On what grounds? That grounds have been met on paragraph 37. But in our case, nobody has argued in nobody's case that rules are ultra vires the parent act. Similar paragraph 37, I will only show you, Lordship. That's for my Lord's satisfaction. Paragraph, okay, page, paragraph 37, which has been read by my learned friend. Paragraph, it only clearly says below. From the reference to the precedents discussed above and taking an overall view of the instant matter, we proceed to distill and summarize the following legal principles that may be relevant in adjudicating cases where subordinate legislation are challenged on the ground of being ultra vires the parent act. That is not so in this case. They are not grounds are given. So, but this judgment really has no relevance in our case. Next case cited, my lord, they have cited, that is the AIR 1986 Supreme Court, paragraph 4, which have dealt with earlier, my lord, paragraph 4. In this, what happened, my lord, the Tenancy Act, and in our case, that the rent is so much amount, 1986, in Supreme Court cases,
That you have already distinguished.
Supreme Court cases have been given to your lordship. Then it
No, AIR is SSC is here.
86 to SSC online.
And 1986 Supreme
Page 129.
Yes, Ratan Arya and others.
Paragraph
State-
4 has been cited.
Right.
And Miller, this is equivalent to 86 C Supreme Court cases. So I have read the Supreme Court,
Yes.
I have a thing. But the case was the premises.
No, you have already distinguished this.
That is now Miller, making the point was the fixation of quantum or monthly rent for keeping that tenancy within the ambit of statutory act or not. That is why that is relevant. In those days, earlier, 400 rupees rent or monthly rent was considered. Above that, will bring this tenancy out of that
So
tenancy.
there was requirement of a change, and that is the reason it has
And
been
that
done.
supported judgment another. I don't deal with anybody. The last judgment of my learned friends are 2024 8 SCC 124. কোথায় গেল আমার এটা? ও বই আছে, বইটাকে দাও। এটা বলবেন না। বইটা কে? বইটা, হ্যাঁ। 2024 8 SCC 124 at page 131 has been cited, has been shown to your lordship, paragraph 22.2. Here, not bonus marks were given to employees. Which employees? Notice, my lord, kindly see the paragraph 22.2. It's administrative, no. Rule provided. Can you see question number 2? This is relevant. Paragraph questions for consideration. The answer, 2 questions arise for consideration are that candidate 22.2. Right? This is the question involved. Is about a bonus marks to the project employed applicants discriminatory and ultra rules? Are the guidelines of such and such date sanctioning the award of bonus marks on a differential basis for applicants with project experience and other applicants invalid? Bonus marks were given on the basis of project experience. That was said. Supreme answer was no. It is valid. Answer also get that. I give the paragraph 47, answer is given. It is valid. Yes, it is. Oh, sorry. Bonus mark. Paragraph 40 answer. But before that, Supreme Court discussed the matter. Before that, Supreme Court discussed the matter in paragraph 30. At question number 2, it starts. Page 135, question number 2. Insofar as question 1 we weren't concerned with, So, by the award of bonus mark is concerned, a careful perusal of the guidelines indicate it was issued before the advertisements, issued before the advertisement, and all that is provided out of allotment maximum marks of 25 per experience. Ordinarily, 2 marks are given. However, if the experience was the employment receiving honorarium and the project run by state government, then he was to be given 5 marks for each academic session with maximum 25 marks. Even if part of the experience was in project, extra marks were provided to all applicants. This is the then. In the application form, there is a specific column, namely column 14, which asks about details of the experience. The form, etc. Form is Miller, and omitting form is not important to your lordship, form is format. Then please come to paragraph 33. Moreover, intrinsically, Rule 13.5, validity of which has been, we have upheld. Evidence is available to show that rule recognizes the experience gathered from project work stood as a higher pedestal, on a higher pedestal, because it was in tune with the nature of the work of Prabodhak. Further, under Rule 25, committee was to prepare. I'm relying on this paragraph. That if this rule, our rule, put the untainted candidates who have served in the government schools for 6 they have been placed on a higher pedestal, that is not wrong. That is not malice. That is paragraph 33. And then judgments are quoted, my lord. Lots of judgments are quoted. Paragraph, no perversity in the criteria adopted. However, in this case, teaching experience was given a higher mark pedestal. And here in this case, same thing, the mark. Then this judgment really supports my case. Lordship, in paragraph 47 conclusion, we find no illegality in the prescription of additional marks for those applicants who had experience of working in the projects. Paragraph 47. From all the judgments I've cited, I'm not given any judgment, will support my case that experience is a legitimate, relevant factor in the matter of selection of candidates.
All right.
Yes, now, Mrs. Dr. Guruswamy has relied on a judgment, many judgments. You see that. It okay, 222.5 SCC, 225 SCC, paragraph. I only just give the reference. Huge compendium.
ব্লু কালারের একটা আছে
Of judgment, I rely.
which one
Paragraph 20 minutes kindly come to.
which judgment
It is 2022, 5 Supreme Court cases, 314, page 314. At page 321 is paragraph 20. When learned T24 at 219.
what is the name of the parties
Name is Satyadev Bhagwat,
all right
the state of Rajasthan.
yes
Huh? Was the compilation?
Yes.
ठीक है only paragraph 2 minute only in support of my argument intelligible differentia. Paragraph, it should thus be clearly seen that division bench in Jagdish Prasad, after considering the record, has come to the finding that government of Rajasthan has conducted several training programs for the persons working with it on contractual basis as well as under different schemes. Training program may mainly pertain to the peculiar working pattern in the rural, etc. Division bench further come to finding participation in such training program is mandatory and non-joining of same would result in non-renewal of service. It has been held the person having special knowledge in working in the state of Rajasthan form a class different from the persons not having such experience of working in the state. It was found that the benefit extended by the state policy was only that of giving a little more weightage on the basis of experience, and all the candidates were required to undergo the rigor of selection process. The division bench has clearly held that the experienced candidates in other states cannot be compared with the candidates working in the state of Rajasthan, as every state has its own problems and issues, and the person trained to meet such circumstances stand on a different pedestal. We are in complete agreement with the aforesaid observation of division bench. Even if the state government in the rule said only state government schools will be, West Bengal government school will be considered. Even then, that would have been sustained by this judgment. Different, well, there is no equality. My submission, there is no equality between the freshers and the person who have served rigors, etc. Just support this, There is no equality, and this judgment relies on that basis. Very clearly says, experience gathered in a particular state will be a factor relevant for appointment in that state. Because of state government, school may have a different atmosphere, which may not be good. So these are the judgments I take. I may not now, may I come to the rules? And on the basis that if the rule is held to be, this teaching mark is held to be valid, then what are the question arises? The rules, which to be given first or thereafter. Can you give me the rules? I will show you. রুলটাকে দাও, যে কোনো রুল দাও। I rely on two judgments of the Supreme Court. What is definition clause? Definition clause do not confer any right. It is not to confer rights on the party. Definition clause is for dictionary for the words. 2010 9 SCC 536 আমার সাইড করছি এটা প্যারাগ্রাফ 31 কপিটা আমাকে একটা আছে 2010 ভলিউম 9 SCC পেজ 536 প্যারাগ্রাফ 31
আপনার বই দেবো কি স্যার
এখানে ঠিক আছে একটু হলে হবে the similar paragraph 31 can come to Justice GP Singh.
Yes.
In Principles of Statutory Interpretation, 12 edition 2010, says that object of a definition of a term is to avoid the necessity of frequent repetition in describing all the subject matter to which that word or expression so defined is intended to apply. This is for convenience, really. In other words, the definition clause is inserted for the purpose of defining particular subject matter dealt with, and it helps in revealing the legislative meaning. However, the definitive clauses may itself require interpretation because of ambiguity or lack of clarity in the language. If definitive clause is ambiguous, then require clarity. But the definition is purpose to give the meaning of the word. Whenever the word, the interview, list of interview occurs in the substantive part of rules, then we have to go back to the definition clause, see what is interview list. is not that interview list that definitely gives any right. It is to help reading this. Now that and schedule to be read in a manner which gives the support to the primary portion of the rule. So like every rule, its definition clause is there, normally section 2 of statute, then substantive part, and then schedule may be added to act. Now I'm just having regard to the can you now read it, I humbly submit without there cannot be a scope of doubt that these teaching mark experiences should be given before interview list is published. My humble submission is this, Milord. There are different categories. Whatever marks can be given to a candidate without having a face-to-face discussion or contact has to be given before interview, which is meant for face-to-face contact. Number 2, interview list is shortened the list of candidates to be invited for further selection. But whatever marks can be given without seeing the face of that candidate are given before the interview, before they decide to see the face of the candidate.
Yes.
The marks have been given, written tests, marks have been given before has to be given. That can be avoided without seeing the face of the candidate. Next, academic qualification, all record, BA or B8, whatever it may be, that can be given without thinking. Teaching experience mark can be given, but by looking at the evidence, whether he has held substantive posts for some, yeah. That's a call for. Then next mark is lecture demonstration, which cannot be given without meeting the candidate face to face. So interview list is prepared on the basis of all the marks that can be given before the interview takes place. Interview is the object of interview. Interview the candidate face to face. Whatever marks are relevant, the teaching experience is not relevant for the interview, for the interview, because that is not subjective test. That is not objective test. Subjective tests are all written. If you didn't test so much, if you have so much teaching experience, then 2 years, 1 point, etc. Maximum ceiling limit. These are all can be given and are to be given without even seeing the face of the candidate. And interview is to now judge the demeanor of the candidate. Then after you have to examiner to see the candidate and see the demeanor and then decide whether to go. You want to see the rules?
Canning starts from page 70.
Hmm?
In our application, rule starts from page 70.
No, rules, logical rules are separately. Rules are a copy there.
Yes, rule is
Rules
here.
also got me. I am reading the rules in my submission in the order it should be read. Substantive part will be read first. In my humble submission. Please, Milord, come to substantive part which starts. Duties, etc., omitting, advertisement will be issued, all right. Then, Milord, method of selection, paragraph 11, rule 11. Method of selection. This is the method of selection. Method of selection. Once application filed in Rule 10, then Commission will arrange for proper and secure custody of online application, etc. Then Central Commission shall form a paper list of candidates for the preparation of database and candidates, making preliminary scrutiny of the age and qualification, which make them eligible to appear in the OMR. For written tests, who are eligible, that will be considered. Like Central Commission shall appoint paper setter, moderator, etc., omitting that. Central Commission conduct OMR-based written test. Written test in duplicate OMR shall be taken. Then central government shall publish its official website preliminary model answers. Key is after that is done. Then 6, Central Commission shall form a subject-wise expert committee comprising not less than 2, etc., but not more than professor, etc. Expert committee shall deal with the suggestion and objection. They go to the model question answers. Then Central Committee shall finalize this equal and upload on its website the final model answers key based on decision of the expert committee and shall evaluate the OMR sheets on the basis of this final model. Etc. For that, no interview is necessary. Then marks is given account. Then 8. Central Commission shall prepare and publish in its website a preliminary list with the details of the candidates to be called for interview, subject to verification of credentials and eligibility category-wise on the basis of preliminary merit score as defined in Rule 2K, Rule 2.1K, ratio, etc. It is preliminary. This paper 2.1K. Now we have to refer to 2.1K now. And 2.1K says interview list definition. In respect of census level means in case of vacancy in post, etc., list of candidates prepared by Central Commission to be called on merits for oral interview and lecture demonstration, category-wise, on the basis of a preliminary merit score that is scored from written test, TAT, for upper primary, and academic score in the ratio of 1:6. Academic score is now defined that includes experience also. Therefore, that has to be seen. Now, similar next order C, after the preliminary interview list is published, then ratio 9 shall be cut-off mark, then fixed. Then preliminary interview list is not final. It may contain some mistake. 10. Preliminary list of the shortlisted candidates prepared by the Central Commission shall be forwarded to respective regional commissions. Then, regional commission shall verify the credentials and eligibility of the shortlisted candidates appearing for interview vis-a-vis their application prior to conducting the interview. Again, my check will be there. Then, after that, application whose credentials have been checked and found incorrect by the Union Commission, and candidates who are found ineligible to participate in the selection process shall not be allowed to appear for interview. So this is, it will check Regional Commission. Then next Regional Commission during document verification, any doubt, etc., take the person. Then during verification, doubt shall take a final decision in this regard. Then 14. Upon verification, respective regional commission shall submit report to the Central Commission as to the outcome of the verification process. Thereafter, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board as specified in Schedule 3, Schedule referred to. After interview, then the interview board shall forward a detailed report to the Central Commission, which shall form the interview list, and on the basis of report of the interview board, prepare and publish the merit list, category-wise, on the basis of merit, as per Schedule 2. Then Schedule 2 comes to a substantive plain object. Schedule 2 comes into play when the merit list is prepared. The merit list shall contain the names of all eligible candidates who have appeared. And what is merit list? Now, definition is given. For that, we have to look at the definition clause. 2L, what is merit list? Means 2L means in case of post of lecture list candidate, etc., category 1, basis of merit, on merit, which shall mean, then, in addition to what has been stated in Rule 1K up to test. Marks obtained in oral interview, lecture demonstration, and prior teaching experience and shall be include all eligible candidates who have appeared for unity. Again, Milord, everything will be number given. Marks obtained on interview, marks obtained on teaching experience, marks obtained on written test, everything will be now considered, and then total aggregate mark on the basis of that written merit is prepared. There's no ambiguity here. Similar, it is when the rule specifically provides that before publication of preliminary interview list, the teaching experience marks have to be allotted. Then may not quote humble submission will say what the rule says and not what rule should have been. It is also settled by Supreme Court judgment that when I see a rule, statutory rules, you could go by what is stated in the rule and not what should have been the rule. Well, it is clearly stated clearly in the rule 11, I've cited, not 11, that it has to be given before issue of preliminaries. And Schedule 2 subserves that principle. Schedule 2 also laid down the chronological order. Schedule 2 also subserves what is stated in the substantive part of the rules. Selection of posts, etc., shall be made on the basis of marks obtained in written examination, educational qualification, prior teaching experience, oral interview, and lecture demonstration. All these factors have determined by Sun Commission in the following manner. It has to be done in the following manner. Manner is sequence. First is written test, examination. Then second is academic. After written test, academic. Then marks is given. No rounding up, etc. Prior teaching experience, 10 marks. Then comes at the secondary level on a government aided school, government sponsored school, calculation on the main submission. Then, Milord, number 3 is oral interview, 10 marks. Then lecture interview, another 10 marks. 20 marks will be considered thereafter. Is after getting oral interview, 10 marks, and then lecture. The oral interview takes place after taking into account the prior teaching experience. It may not, it rather subserves the rule 11, sub-rule 8. Chapter 8. Formula, this must be done before that. Number I humbly one thing, that the teaching experience is mark given in the schedule. It cannot be severed from the rule. It's not a severable clause. If this clause is quashed by the court, teaching experience, then the entire rule will change. It will not 100 marks examination. It will become 90 marks examination. That will be modification of the rules itself. Object and purpose will be defeated. But also no argument is made that is severable. So that my submission it cannot be not severable. But I cited judgment not that definition is meaning of that. Another judgment I can cite 2013 9 SSC 584. My submission is definition clause do not confer any right to anybody. Definition clause only clarifies what the meaning of the substantive part. This judgment paragraph 30 may not kindly come to. I coming to an end. Regarding definition clause, paragraph 30 of this judgment. When the word securities has been defined under the SCRA, its meaning would not vary when the same word is used at more than one place in the same statute. Otherwise, it will defeat the very object of the definition section. Accordingly, our answer to the first question is that the provision of SCRA would cover unlisted security. It depends. Definition has been given That has to be, if the interview rules has been repeated in the rules many times, same meaning has to be given. Merit list has been mentioned in the rule, substantive part, it will give same meaning as defined. So it is allowed repetition. That is the purpose of object or definition clause. Object is not to confer substantive right by definition clause. Definition clause do not concern substantive right. And schedule lordship has seen and judgment Supreme Court is there. Yeah. Milord, those are my humble submissions, Milord. Since my point is being raised the other side, the appointment is bad, Supreme Court, etc. It is apparent, Milord. Take it out, take it out. Even I stick it to doctor. 61 delete. Oh, 8. No? No, paragraph 5. Yes. In this, citing a judgment, Milord, in this case, the agreement under which work was done was not proved, failed to prove. But work was done, or goods were supplied. Milord Lordship knows the well-known principles of Contract Act section. My untended clients had served not to lawfully serve because they come and not to do so gratuitously, not intending to do so gratuitously. Therefore, they are entitled to retain the benefits, get some benefits. That is the judgment I'm
But
saying.
then monetary benefits you are already retaining.
Yes, my lord.
Monetary benefits you are retaining.
Yes,
The
that's
Supreme Court has permitted you.
I'm getting that right to appear in the examination also.
Right.
Also, and with age relaxation. And now the rules have given some parties teaching experience for 10 marks also. What is the ground attack? Isn't to favor the class. Very good. It is a malice. They have not argued that if they intend to favor this classified class of untended candidates, why that will be wrong thing? Is that a wrong thing to do? I've shown you, Lordship. So many judgments they have cited to show the experience has got a different pedestal. Malice in law. How is malice in law? Malice means something wrong we have done. They have not argued, with great respect to them, that giving up the experience 10 marks is illegal. We have done something illegal thing. No. Then how it is malice? That's my humble submission, Milord. If the criteria of reasonable nexus is fulfilled, if that incidentally benefit a particular class of candidates, that will not vitiate that. Incidentally, but the intention is to. But in this state, suffering by unemployment, those people got unemployment. Through their own merits, they got unemployment. They were victimized because of circumstance. It is very clear the Supreme Court had sympathies for them. Division bench did not pass any order in support. The Supreme Court modified and said you can retain benefits, except I don't repeat. It was clear the Supreme Court heart was bleeding for them. And Supreme Court could have given them such benefits as much as they could give at that stage. That, if I may quote Rabindranath, don't mind me, Lord. দণ্ডদাতা কাঁধে যাবে দণ্ডিতের সাথে সর্বশ্রেষ্ঠ সে বিচার. Supreme Court has done it. They have had to compel to terminate, but their heart was bleeding for them, bleeding for the Dondodata did cry for the Dondite Shate by Supreme Court. Lord, I have no doubt in my Lord's courtroom, Lord, also consider that in this country of unemployment, a person secured employment through his own merit. Should they be deprived of that? Should they be asked to appear again in a test? Second time they're appearing. Third time again. This is not, it will never end. Whatever something done, the applicant will come to challenge that. Well, those humble submission, my lord.
So this you are not relying.
My lord.
This one you are not relying.
This point,
Yes, 1961 SCC, Subramaniam, you are not relying. Just now,
cited that
gratuitous,
paragraph 5 only.
gratuitous
Paragraph 5.
employment.
Also similar. Paragraph,
All right.
paragraph 5. Similar. Counsel for the appellant submitted as
Quantum merit is there.
as in the view of the High Court, respondent failed to prove oral agreement pleaded by him should have been dismissed, and they should not have awarded compensation, quantum merit, which was not claimed even. It was urged that the respondent must succeed or fail on the case pleaded by him, not on a cause of action not pleaded. In our view, there is no substance in this contention. As I've already observed, in respect to additional work done by the respondent, both the parties set up conflicting oral agreement. These were not accepted by the High Court. If a party to a contract employment has rendered service to the other, not intending to do so gratuitously, and other person has obtained some benefit, the former is entitled to compensation for the value of the service rendered by him. Is it on this basis Supreme said you retain your salaries? It is the basis. It is not charity really. It is our law, Section 70, Contract Act 73, Contract Act. If I done, then evidently, respondent made additional construction to the building, and they are not doing. In our case, we did not serve gratuitously, and there which the NBS schools were run, the students were taught by me, taught by clients, and there is no charge of any or any blemish on their teaching. And therefore, below the entitled law, what are entitled law, Supreme Court granted them. It's wrong to think that Supreme Court acting very gratuitously. For that I submitted judgment below. That is why Supreme Court granted this benefit, the benefit of returning seniority, etc.
So you must be.
Consider the whole dismiss the writ petition because it is made some their application made some the group where we say job hunters. Whenever a job is given, they apply by writ petition for cancellation of job. Unfortunately, they have not succeeded. 32 jobs have been retained. Whenever a job is offered, this group will apply for cancellation of job. It is, it is quite pathetic, the lordship can support this. They are not being benefited thereby. Anyway, whatever. Those are humble submission, get to you.
Just a few minutes.
After recess, start off with you.
So good, the picture for it. সে অন্য ম্যাটার ফিক্স আছে তুমি নেবে তাই বলছি
I'll carry on with him.
because you went to some other matter fix that anyway.
There are so many matters fixed. What can be done?
I am now take my lord.
All right.
I'm thankful to my lord.
এটা প্রদীপকে দিয়ে দিই। Yes.
Probably Lordship is using Boishaki judgment separately. Because my
Boishaki's judgment?
the documents that I shall be referring, I shall be referring from Rahul's oppositions, which has been filed by me.
All right.
Now, Lordship, may kindly keep it aside.
This is in which matter? This
This is in Rahul. That is
in Rahul.
30.
রাহুলেরটা আলাদা রকম।
Kindly keep it
এইটাতেই রাহুল আছে।
aside.
ওটা
Lordship,
রাহুলের
my
টা
views.
থার্টিন আজকে 13 আছে, কাল তো থাকবে না।
In addition,
রাহুল কস্ট টাইটেল আছে তো। ঠিক আছে। Yes.
Yes. Lordship, first, may I first say there are 3-4 points. So I will just give the points and then I will make my submission.
What is your status?
My status is I am appearing for untainted candidates who have been appointed starting from counseling 1, 2, 3, 4, 5, 6, 7. So up to 2 within the
Untainted job losers.
Yes. My first sentence shall be the judgment of the Honorable Supreme Court has absolutely clarified that who are tainted and also who are not tainted. The same judgment also have shown that we are not tainted. Kindly take, my lord, paragraph 3, Boishaki.
Yes.
Paragraph 3 equals to 2 categories. Short para, the appellants before us are the selectees, some of whom have been working for over 5 years. They fall into 2 categories. Category number 1, selectees with purported evidence and material indicating wrongdoing. Number 2, other selectees who claim that they were validly selected and have committed no wrongdoing. So that's the beginning of the Boishaki. 1, some evidence wrongdoing, some they are claiming, that's we. Kindly take paragraph 22.
Yes.
We have 4 reports submitted by CBI. We would like to quote some of the passages from the report dated such and such submitted by the CBI in compliance with the order dated such and such by the High Court. Now, thereafter quoting started, Lordship may kindly come to internal quoting paragraph 9, that is page 25.
Yes.
That during investigation, the server database, kindly mark this portion because there are 2 aspects. One is what SSC claimed, that was taken by the CBI. Another was seized from the Pankaj Bansal. That during investigation, the server database of the commission was seized by the Central Bureau of Investigations containing, these 3 words are important for us, all the data pertaining to selections test group D, group C, 9, 10, 11, 12. So internal paragraph 9 equals to entire data of SSC seized by the CBI. Next paragraph 10. That during investigation of the case, 3 hard disks were recovered on such and such date from the residence of Pankaj Bansal, ex-employee of Messrs. NASA. Lordship need not read that. Now kindly come to paragraph 11, the last 3 lines, which establishes that the data contained in the 3 hard disks recovered from Pankaj Bansal's possessions were not contaminated. One seized from the SSC server, another from the Pankaj. CBI found Pankaj data not contaminated. Kindly thereafter paragraph 12. That a similar exercise of matching the data available on the hard disk of Pankaj Bansal's with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two. This is the beginning. In as much as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examinations in the case of many candidates was resorted to, and such candidates, kindly mark this, were identified. Full stop. The comparison of this actual/genuine OMR marks with the OMR marks available in West Bengal School Service Commission server shows that there is manipulation in 952 numbers of candidates of some there are numbers. So before moving ahead, CBI found genuine data with Pankaj. CBI found data from SSC. CBI matched. What was matched? Not few. All the data with the SSC, all the data with the Pankaj comprised of everyone. Group D, Group C, 9, 10, 11, 12. All were matched. After that, it was found X, Y, Z numbers were not matching. Thereafter, kindly take 13. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons, and officials of NIASA. These emails contained list of candidates whose OMR marks were found to be increased in the server of the commission. I'm trying to show the meaning spread over everywhere in the judgment of the Honorable Supreme Court regarding identified. And then contrast why the Honorable Supreme Court has said not specifically identified, they will get these benefits, not everyone. Besides this, emails have been exchanged between the staff of NIASA themselves containing manipulated data of candidates. This shows the complicity of the officials, such as not necessary. Thereafter, kindly see internal 15, next page, just first 4 lines. That it has emerged from the investigation that before leaving NIASA, Niladri Das and his staff retained all the data. Well, I'm only on the point, all the data pertaining to recruitment of such and such, including data of CD with them. Thereafter, 18A on identification. As discussed in the preceding paragraph, the hard disk recovered from Pankaj Bansal contained the marks of written examinations, typing text, etc. These marks, when compared with the marks available with West Bengal School Service Commission server, resulted in the identification of candidates whose marks of written examination typing test were manipulated. So the paragraphs are going in the same tune. Now, internal para 21. That the present status of all the above mentioned 4 recruitment cases of CBI is disposed of from investigation, where multiple charge sheets in each such cases have been filed by the CBI before the learned trial court. Now, kindly see, my lord, thereafter, this is by the Honorable Supreme Court. The facts stated in a report dated such and such submitted by the CBI speak for themselves. Thereafter, paragraph 25, my lord, before I place 25, after recording what CBI has found and without adding anything, the Honorable Supreme Court having said it speaks. So that's what the truth CBI is saying, so far as this matter which was before the Honorable Supreme Court. After that, the Honorable Supreme Court also did an exercise in the table number 1, paragraph 25, for identification. First, paragraph 25, in the written submissions filed on behalf of the School Service Commission in this court, 2 tables have been furnished. Table 1 pertains to candidates who either jump rank or were appointed despite not being in the panel. Lordship may kindly see the numbers. Table 1, since I'm not taking the number of the group C and D, since I'm appearing for the 9, 10 and 11, 12. So rank jumped 74, 20 and out of panel 111 and 18. So total 185, 38. So total I have made a calculation. It is 223. Lordship may kindly mark 223 equals to rank jump and out of panel. Now table 2. This is the manipulating of the OMR sheets. In C and D, the number was so much. So I'm not touching that. Lordship will see there are 2 columns. One was the number of candidates with alleged OMR score mismatch as per the CBI image. That's a Pankaj when compared with the SSC. And out of that, actually who got the benefit, who were appointed. So that figures Lordship will see 808 and 772. So put together 1580 is the figure. So 223 and appointed based on this OMR corruption 1580. Now 1580 was further verified, paragraph 26. In another written submission filed on behalf of the School Service Commission in this court, it is claimed that on further verification, the following details of the candidates, it either jump rank or were appointed despite not being personal, and thereafter they gave a figure. What I found is the only change was there that rank jump there 74, 20, 100. So there is no change. In B, there is a change. 1580, which was the total, now it became 1568. Lordship may kindly see capital B, persons identified having dispute in OMR issue. The numbers are there 796 and 772. If Lordship add these two, it becomes 1568. That number is not that important. All I'm thereafter, Lordship may kindly see the language of the Honorable Supreme Court. Page number 30, last paragraph. 1498 out of panel candidates were illegally appointed. We don't belong to them because 926 candidates were involved in the rank jumping. We also don't belong to them. 4,091 candidates were recommended. Let me kindly mark this 4,091 equals to all teachers equals to 1791 because it is 1568 plus 223. So it becomes 1791. In fact, that's the reason the Honorable Supreme Court did not grant Group C and D to continue their service because they found the massive corruption was statistically more in Group D and C. So 4,091 is the number specified, identified by the Honorable Supreme Court on the basis of the CBI's report, which was accepted by the Honorable Supreme Court. Out of 4,091, if Lordship take the figures from the table itself, I have calculated the detailed calculations, Lordship has to add it, 1568, which was originally 1580. If I give the number, Lordship kindly take.
Anyway, the numbers are not.
Yes, number is not important, right? Just that's the for idea purpose. Lordship can take the number because I have checked myself. 1791 is the number for the teachers. 1,791 teachers. Their marks in a corrupt method were increased, which was detected, found, identified, and recorded by the Honorable Supreme Court. So this is the context. In this context, thereafter, Lordship may kindly come. Paragraph 31, which was relied by Mr. Bhattacharya.
Yes.
West Bengal School Service Commission has also tried to justify the extension of the term of the panel as noted above. The time period of 1 year specified in Rule 21 for the destruction of the OMRCs coincides with the time period specified for the validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teacher class 9, 10, 11, 12 were made after the expiry of panel. This is illegal and contrary to the rules. Reliance on the orders, judgments of the High Court in stray cases of rank jumping where the High Court directed to appoint candidates after the expiry of the validity of the panel would not have any significant impact. The court at this stage was not concerned and aware of illegalities in the appointment procedure and had, kindly mark these 3 words, not specifically examined the question of appointment after the expiry of panel. Paragraph 31, according to my understanding, is after expiry equals to illegal. Yes, I agree up to this. Yes, after expiry has been found, after expiry appointment has been found by the Honorable Supreme Court illegal. Now thereafter, kindly take paragraph 45. Before because that's the main paragraph, before I place it, what I have found from the reading, when Lordship reads it in entirety, Lordship will find there is a 2 completely separate branch. One branch is coming from paragraph 46 and paragraph 47, coupled with 31, that is we. 46, 47, 31 illegal, that's we. And there is a conspicuously differently identified branch is in paragraph 22, that internal paragraphs, read with 25, 26, that identification of the column, and then paragraph 45. So may I kindly take 45 first. So 45 is the result of one. I would also try to argue against me to find out whether my point has any negativity, so that I can has my point also. I stretch 31 to fullest extent to mean that 31 means illegality, and therefore once it is illegal, whatever are the directions which touches upon illegality, that will also touch me. So I take that. So I want to address that. So after I said dealing with in 2 different ways, one way of dealing was identifications based on Pankaj's data, and the other is the institutional failure and illegality in 31. Now the Honorable Supreme Court comes to what is to be done. First is 45. The last question relates to the relief and whether it requires any modification. We find no valid ground on reason to interfere with the directions of the High Court that the services of tainted candidates where appointment must be terminated and they should be required to refund and salaries payments received, since their appointments were the result of fraud. This amounts to cheating. Therefore, we see no justification to alter this direction. Kindly also read 45 with 51. Kindly read 51 also. Accordingly, we uphold the impugned judgment, cancelling a block entire selection process. But this but is the according to me our savior. But have made certain modifications in the directions issued by the High Court. So now I have to show before your lordship what is that but. Kindly come to 46. So 45, to me, 45 equals to fraud, cheating. So the Honorable Single Judge was right in direction for not only termination but also refund of money. That's all 45. That if I say once more, since there, the word there, I would relate with paragraph 25, 26, which is based on CBI's 22. Fraud. Now, why do I do so? Because the very next paragraph, there is a separate branch altogether, where there is the modification has been made and for a reason. For candidates, now this is 46, not specifically found to be tainted. I just pause for 1 second. There is a difference between two sentences. For a candidate not found to be tainted and for a candidate not specifically found to be tainted. My understanding is this, that the Honorable Supreme Court took the pain of that 4 reports of the CBI, read each of the parts of the CBI report, and thereafter found that there is a truthfulness, and then that chart was made. That identification of the chart, according to me, is the specifically found to be tainted. The entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 14 and 16 of the Constitution. So therefore, if I use these synonymous words, for candidates not specifically found to be tainted, so I want to use as we. Why? Before I proceed, kindly, my lord, for the time being, assume there is no judgment of the Honorable Sir for the time being, because lordship would be seeing not only from just a point of law, also lordship would be seeing independently also. Kindly visualize of a situations that as a candidate, I have participated in the competitive examination. I have found that my name is there in the panel. I am waiting so that one day I would be appointed. That's a very normal phenomena we see in the society. I get information that counseling starts, you come. I go there. I am successful because my name was there and I am appointed. Kindly, my lord, visualize this most ordinary common phenomena existing in our society. If anything is not attached to that particular candidate, like he has paid money or he has used some other method, his or her act of responding to the counseling for getting the job because he or she was in the panel, can anyone say in for any stretch of imagination that that is an act of fraud? I'm just, because after all, law is not that something, society is one thing, law is a completely different thing. It's society to run in a properly. That's the whole purpose of the law. And in a deeper level, that's a justice. I was only trying to understand this, that I prepared, I sat in the examination, I found that I am successful, I am waiting. And contrast it with the institutional failure. Because in the SSC, they have said there was some orders, some difficulty, and that's why even the first counseling started after 6 months. So ultimately, when 7th counseling happened, couple of months were delayed. So if lordship takes into account 1 year, right. In fact, my instruction is that this mismatches the numbers. More are in the first counseling and second counseling. So leaving aside that, there are large number of petitions also usually, not in this case, also come before this honorable court saying that my name is in the panel and I have a genuine grievance that I have not been called. Usually some kind of directions are given because there is no fraud in that. So what is my respectful submission is that fundamentally for a candidate to wait for a call for counseling because he or she has done good and her or his name is there in the panel and thereafter getting an appointment, that itself, nobody can say that there is an element of fraud. First part. Second part is there was a probability that I was a part of the fraud. Now that is removed from the Pankaj and that mismatch that has been done. So once that exercise is done from the all records and it is found I am not attached with the fraud at all, should I, this is my point. Can I be said to be like equal to a person who is a fraudster? Kindly see my devastating.
See, the fraudsters are out. What are you driving at?
Yes, I am driving at this, that one of the submissions of Mr. Bhattacharya was in paragraph 31, Supreme Court has observed after expiry appointment is illegal. And then Mr. Bhattacharya was trying to connect that illegality and tried an interpretation that since it is an illegal, therefore, I should also be treated as tainted. Now, my response to that, yes, it is illegal. Yes, it was found to be illegal. But the word tainted has been used not for the institutional illegality. Tainted has been used for the persons who have been identified by the CBI and for whose names are already there, not the persons who have been appointed after expiry but honest. So paragraph 31 is for the purpose of declaring the selection process to be set aside. It's like there are two different elements.
One, but then is it only for the purpose of the prior teaching experience that you were saying?
No, prior teaching I will come later.
Then what?
My only purpose is this, that today there are thousands and thousands of persons. May I just give the fact? There were total 8 counselings because that part of the CBI report is also in my oppositions. They have given the dates and everything. And they found, even the CBI also found up to 7, there was nothing wrong. Only 8, they found it was done absolutely illegally. So all of us, we were called in the counseling and thereafter appointed range over from 1st to 7th counseling. If the interpretation of the writ petitioner is accepted, that paragraph 31 means illegality and illegality means we are also tainted, then we are completely gone. Gone in a sense, our participation, we cannot also participate because one of the responsibilities that has been entrusted upon by the Honorable Supreme Court, that not even a single tainted person can slip through. Now, assume that Lordship holds an interpretation that Lordship feels that even if no matter that those who are in the CBI list, they are of course tainted, but those who are also appointed after the expiry of the panel, they are also tainted. Then what are the effect we get? The first effect we get is, once we are also declared as a tainted, that means for us everything shut. Not only shut, then as if we have practiced fraud, because even we are also up to December, we are going to school, we are also rendering services, We have participated in the selection process. So now everything comes to an end. Now, my inspiration was not independent. It is from the Supreme Court judgment itself. May I just place 46 once more? Kindly see, my lord, the 45 is completely a separate paragraph from 46. There was a purpose of the Honorable Supreme Court to make 45 as separate from the 46. The purpose was this: 45 was you return the money because you are a fraud. That is 45. 46 is there were lot of violations. Therefore, though you are continuing the service for last 5-7 years, but still you lose the job. So selection process is set aside. These two things are different. Maybe there is a common connections up to the cancellations, but thereafter it's different. May I just read for my satisfaction? Both 45, the last question relates to the relief and whether it requires any modifications. We find no valid ground or reason to interfere with the directions of the High Court that the services of tainted candidates where appointment must be terminated and they should be required to refund any salaries, payments received. Since this is the reason, since their appointments were the result of fraud, this word, the result of the fraud, is based on paragraph 22, the internal paragraphs, then the column in 25 and 26. This amounts to cheating. Therefore, we see no justification to alter. This is not plural, this THIS. So, this direction, that's the directions of the Honorable Single Judge for returning the money by the persons who have done fraud, who have done cheating. The Honorable Supreme Court did not interfere. After that, the Honorable Supreme Court, 46, for candidates not specifically found to be tainted. Well, that answers, that's our savior. This first part of 46 is a completely portion carved out for the honest persons like us. For candidates not specifically found to be tainted. What happens in their case? Returning money. In our case, the entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 1416 of the Constitution. As such, the appointments of these candidates are cancelled. Kindly see thereafter the word. However, this is the, my lord, this is the paradox. However, candidates who are already employed, that's us, need not be asked to refund or restitute any payments made to them. So therefore, I would put it this way. However, we are not treating you honest persons like 45. However, their services will be terminated. So this is like, there is a larger circle. Everyone gets affected. Honesty, dishonesty doesn't matter. That's the termination. That's the selection process goes. And there is a smaller circle. Because you are a fraud, because you have given money, because you have done corruptions, and that has been identified from the all records by the CBI, you return the money. So 45 equals to tainted, who has to return the money. 46 equals to not specifically found to be tainted. Now, why I am using this? Kindly see the word 46, the first words, for candidates not specifically found to be tainted. So that assumes there are some other persons in the same judgment the Honorable Supreme Court found to be tainted. Who are they? Are they of everyone under paragraph 31 because of the expiry of the panel? Then 46 doesn't have any meaning afterwards, because then it has a word, as I say, however. However, candidates who are already employed need not be asked to refund or restitute. That's a complete contrast from 45. Any payments made to them, however, their services will be terminated. Furthermore, no candidate can be appointed once this is of course. Then kindly see next para. Then 47. Now 47, this is another hint that in the 40s. So if I put it in this way, 45 equals to tainted, corrupt persons, return the money. 46 equals to you lose your job, but because you don't come under 45, you don't return the money. But still, because you are a part of this institutional failure, this entire selection process goes. 46. Now in 47, there are some persons who also had a earlier job. Now they thought maybe they want to come closer, or maybe they want to upgrade. So they also sat in the examination in 2016. The Honorable Supreme Court in 47, may I just place it, that 47, Lordship might find, if I can use this word, there is a same frequency in 46 and 47. And there is a different frequency in 45. The frequency in the 45 is the frequency of fraud and corruption and cheating. And the frequency in 46 and the 47, that is all about gross violation, violation of Article 14, 16, institutional failure, and thereby cancellation. And 47, some of the appointed candidates who do not fall within the category of tainted candidates. Well, so therefore 47 also begins with similar way 46 started. Can you see, my lord? 46 starts with 4 candidates not specifically found to be tainted. 47 also same. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. That's the old job. In such cases, although their appointments are cancelled, that means they are like us, they also lose the job. These candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. These applications must be processed by the respective government departments within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of the previous appointment and the rejoining will not be considered a break of service. Their seniority and other entitlements will be preserved, and they will be eligible for increment. However, for the period they were employed under the disputed appointment, no wages will be paid, state governments or autonomous bodies. Further, if required and necessary, supernumerary post. Kindly see, my lord, same frequency between we and 47. Factual difference.
All of you who you are representing were appointed after expiry of the panel.
Most of us probably, because it's a mix, but as my understanding, because in the conference, as they said that the majority of the absolutely clear tainted corrupt persons, they were in the so-called within expiry, first and second panel, most of them. Kindly see, my lord, I would say how the Honorable Supreme Court have kept the similar frequency for both of us, 46 and 47. For 46, because we are untainted, we are permitted to, though we lose the job, to participate afresh.
Because does untainted and specifically not tainted mean the same?
It does in this context. Because one of the things.
Very well. I got the answer.
May I also say why do I say so? Why lordships give dictations or writes the judgment? This is not like a scientist in the laboratory in a mathematical precisions doing something. So therefore, every time when lordship's judgments have to be understood, we have to understand the context and in what circumstances. So if I go the etymologically or deep, anybody can make a thousands of one different. But in this context,
synonymously used.
Yes. Yes.
So does it mean that if there is total number of say 10,000 candidates,
Yes.
and out of which say 500 or 1,000 have been treated as tainted,
Yes.
then the other remains untainted or not specifically tainted?
Absolutely.
Right?
Absolutely.
If that be so, then the commission is coming out with a list of tainted candidates.
Yes.
Others become not specifically tainted or untainted?
Would your lordship say it once more because I missed.
There are, suppose,
Yes.
in small figures,
Yes.
1,000 candidates.
Yes.
Out of them, say 100
Yes.
have been found to be tainted.
Correct.
That means the other 900 remains untainted,
Correct.
non-tainted, not specifically
Absolutely.
tainted.
Absolutely.
This is the
Yes. I think it is to my understanding it is absolutely clear.
right.
Because the lordship will see that as I was using how the judgment of the Honorable Supreme Court was clearly resonating with the CBI's reports. It's not resonating differently. It's in the same frequency that I have stressed on the words all data of Pankaj versus all data of SSC. Then data of Pankaj was not tainted, and data of SSC, my lord, only used to match whom actually they gave the benefit because of the corruptions, and thereafter they found these are the corrupt persons. Kindly see, my lord, the deeper aspect of the justice delivery system. I was thinking this. On one hand, it is your lordship should be ensuring that any process is free from corruptions. Therefore, there has to be absolute thrust. No corruption slips through. No tainted slip through. Simultaneously, just for a hypothetical reason, assume of a candidate who is honest. Suddenly, for no reason, if he is stamped as a dishonest, in my most respectful submission, I would say that would be if the justice delivery system is not, it does not protect that candidate for whatever reason, to my understanding, that would also be equal failure. Because there are two sides of it. It's just to find out the good should be preserved, bad should go. So while doing the act of bad must go, there is a simultaneous, I would say it's a simultaneous also, that every time your lordships do so, also ensure that a good person suddenly for no reason doesn't become bad. So once we have been found to be untainted, which have been synonymously said to be not specifically tainted, today, based on an interpretation of 31, which is, I would say 31, if lifted from the whole context, it is possible to give an interpretation of that. But if 31 is put in the place and read with 25, 22, 45 different treatment in 46 and 47, in my humble understanding, my lord, the only one and only interpretation is that if you are a corrupt, you are tainted. If you are tainted, not only you lose the job, you also return the money. If you are not a corrupt, we feel for you, but you also lose the job. If you are already serving, you get back, and not only get back, you get the continuity of the service. But since you didn't have a job earlier, for us, you participate afresh. This is in 51. That's the reason, my lord, I say that. No, then 49, may I say 49. Before 49, just 51. So for returning money in 45, the Honorable Supreme Court found that the Honorable Single Judge was right, and therefore we are not interfering. Perfect. But then 51, the Honorable Supreme Court had to modify, because in modification has already been done in 46, 47. 46, 47, 46 for us and 47 for who also had a previous job. That's all about 51. Accordingly, we uphold the impugned judgment, cancelling a block entire selection process. This is the word. But have made certain modification. Rachime Kali Mark, according to my understanding, this is modifications is in 46, 47. In the direction issued by the High Court. Because the High Court, though when I read the judgment of the division bench, in fact, there is a possibility, my understanding was that possibly also High Court did not say so. High Court also, but maybe the language, there is a possibility in the High Court judgment to be read as if the High Court wanted everyone is tainted. But if the other paragraphs are read in context, that will not be the interpretations. But once the Supreme Court has said, well, there is no requirement, because 51, my lord, the upholding is, Lord, you may kindly see the entire selection process, that cancellation, that's the upholding. But have made certain modifications means the 46, 47 and 49 that we can also participate again. So on this judgment, I will only say one sentence, and I will conclude on this topic. Therefore, my lord, the added respondents who have been appointed because of their merit in a better situation, my lord, they are untainted. It can be used as they are not specifically tainted, and therefore paragraph 31 of the Honorable Supreme Court judgment does not make them tainted. Paragraph 31 is only for cancellation. Now I will come to, well, I began first with this because if we fail on this point, then we fail everything. On this point, if we fail, in a sense, if in case there is an interpretation that in paragraph 31 the Honorable Supreme Court has said illegality, and therefore we are also tainted, and then the only, in fact, my lord, the situation is this today, even the beneficiary of 47, because I am the not in this matter, in another matter, there are about more than 200 persons who are working in madrasa. Now all prepared, everything is done, ready. Madrasa is also going to give them appointment because they had an old job. But now because of this, that whether persons who were appointed after expiry of the panel, are they tainted? If they are tainted, then they will not get any benefit. They should be denuded of all the benefits. They cannot participate. They have to return the money, all. So that is, in fact, everything is, as I said in the other matter, that even some schools, when they want to go, someone is saying, wait, let us understand whether the Honorable Court ultimately holds that you are also tainted or not. This is the situation. Well, may I now go to the rule point? Well, before beginning on the rule, I shall be slightly using Usually, my lord, as a counsel,
Yes.
now, my lord, I shall be requesting your lordships for some time to use the lens of a mathematics, leaving aside the law for a few minutes. And then lordship will have a very beautiful angle of this matter.
Yes.
Well, this is now I am on the rule. 10 marks. Well, I have studied the rule thoroughly, and I spend lots of time in the rule, and I had a couple of questions. Before lordship looks at it, may I just then I have tried to use, leaving aside the law. Law will come, of course, come, but I found mathematics is one of the best things by which we can look everything in an equal manner. So why not I exclusively use mathematics to give to explain, does it really tilt? Firstly, does it tilt? Secondly, if there is a tilt for 10 marks, is it reasonable or unreasonable? That's a law point. Firstly, does it tilt? Now, there are 100 marks. Out of 100, 60 is for written. Academics, that is qualification parts, that's 10. The bone of contention is 10 prior teaching experience. Now, when I say 10, I would be requesting your lordships to look at not as a 10. Look at, kindly take the rule. Kindly straightway come to the schedule 2. That 25, that's there. Lordship will first kindly see. First, I would be saying on an area where there is no problem by anybody. That is educational qualification under 2A. Nobody has questioned that this is wrong. How much is the marks? 10 marks. Now, this 10 marks is to be given under 3 buckets. The buckets are 60% to 100%, he gets the 10 completely. And then second bucket is 60 to 50, he gets 8. And then 50% below. So if I put it this way, below 50, he gets 6 marks, 50 to 60, 8 marks, 60 to 100, 10 marks. So therefore, there is 10 marks spread over under 3 buckets. Nobody has any grievance on that. So everyone is recognizing that it is possible that if someone is better in the educational qualifications, his bucket may be different one.
This was not there in the 2016 recruitment rules. This bifurcation was not there.
These 3 buckets.
Right. Did you make any comparative chart between the earlier rules and the 20?
I did with the 2007, but I would do that.
Yes, please.
I would do that. I would do that. I was trying to, my lord, because my mind was to find out some mathematically. First, I was trying to understand where do I stand from a neutral point of view. Thereafter, I will make my submission. I found for educational qualifications, there is a bucket, 3 buckets. So this marking. For prior teaching experience, my lord, that is more granular form. There are 5 buckets. Because it says
2 marks per year.
Yes. So that means if someone has an experience of 1 year, he gets 2 marks extra. So when lordship is looking into this issue, it's not necessarily an issue of 10. There could be some persons who has only maybe 1 year or 2 year. It could be 2, it could be 4,
there can be somebody who has got below 56 marks.
Yes.
And has 5 years and
Exactly.
6 years
Exactly.
experience.
Yes.
Who
Yes.
gets the 6 marks and the 10 marks 16.
Correct.
And somebody who's got above 60
Yes.
merit wise stays at only 10.
Absolutely. Right. Exactly, I was trying to make a contrast. Now, my lord, kindly take my third page. Pagination. The last, where the Roman 6:1.
Yes.
What it takes for a freshers to win. I was trying to understand the freshers versus we.
Yes.
I found some interesting mathematical thing. 1 year experience, it requires the freshers to get only 2 marks more in the written. So written is 6 times more powerful because it's 60 and this is 10. 6 times more powerful. In the entire selection process, if someone is a better candidate, in a sense, if someone has written 2 marks better than someone who has an experience of only 1 year, there would be a tie. For 2 year experience, freshers has to be better by 4 marks. And I have come to, for 3 years, 6 marks, for 4 years, 8 marks, and for 5 years experience, a freshers needs to answer better 10 marks. So if Lordship kindly take Roman 7. What I am trying to draw is this. This means that written exam is 6 times more powerful than experience. The above example may demonstrate mathematically that number one, a freshers who performs well in the written examinations can easily beat even a candidate with maximum 5 years experience, but he has to be a better student. Number two, the experience advantage can be neutralized by scoring an equivalent number of additional marks in the written examinations. So it's not a dead end. It's a Darwin's survival for the fittest.
Here, everyday matters are moved for 1 mark.
Yes, correct.
In fractions.
Correct.
And prior teaching experience, the maximum is 10 and the minimum is 2.
Yes.
So it has a deciding factor.
It does. But I'm saying, Lordship, kindly lift the veil of it. Kindly go into the factor. The factor is this. If you don't have experience, what do you have? For an example, my lord, many of us, if we compete today with a
pressure,
a 10th semester law student,
right,
I am 100% sure that we will fail.
Yes, I know it. I am aware of it.
So therefore, life requires skill.
Right.
Now, skill can be said in thousands and one words. Experience is one of the expressions being used where it's a life skill, which is the truth. Now, if somebody has this skill of life to teach students, to match that somebody, one needs to be a better student. I could have understood that his door is shut. No, he has 6 times more powerful avenues where he can compete. So therefore, the mechanism becomes this. If you have to compete with a person who has a skill, that's an experience, you have to be better in your studies. In 60s, in that, now kindly take the first page. I've tried to all the situations. Freshers versus 5 years. First example is the example of tie. Freshers
don't go to this such minute details possible.
No, I'm not minute, but I'm only trying to, my lord, because sometimes what happens, my lord, unless Lordship is looking, if Lordship looks at the this issue, that there are so many persons who are having identical marks. This is on surface. If Lordship go deeper aspect of it, Lordship will find the performance of those so many persons. So my endeavor before your Lordship is this, that the performance, there are two sides of it. One is the skill side, another is you have to be a better student. I could have understood it is impossible that the written examination is not of 60, it is of 30. Then it would be a Herculean task, because my instruction is our total number of vacancies are around 35,000 and around 20,000 are actually they have got from the freshers, because freshers are always better in academic, bound to be. Well, their processors are always better than us. It is the normal thing. That's the evolution. But in that evolution, does it recognize the skill of experience or it does not? Or does that recognition of experience, does it make that competition so difficult for them that it can be said to be violative of Article 14 or not? To answer that, in a deeper level, I say that if a freshers gets 48, when a 5 years candidate, I'm not saying even 1 year to 5 years candidate, he gets a 38, educational qualification, I take it everyone is getting 10, both of them will be having a tie. Both of them would be a 58. And for a freshers to win, for an example, example 2 I have given, that in written examination, if a freshers gets 50, in that case he would be winning. And that the example with the 5 years. Similarly, for 4 years, to win freshers, he needs to have written examination 47, basically only by 2 marks. So sum and substance of this, my lord, that's why I said I would be using a little lens of a mathematics, that if Lordship look at a glance, of course it makes a difference.
And you have not added those marks which have been given to all on attempt. You have not added those marks, not even attempted but given marks. You have not added those marks also. The answer scripts have been published, and there are marks given. Two answers in one question is treated as right. Without even attempting, you are getting marks. Anybody who attempts also get marks. What is this?
May I say this? May I say
Yes,
this?
please.
Well, life will give thousands and one problems. Now, Lordship is already having won this because the Honorable Supreme Court has entrusted. It is impossible to solve every problem. Maybe that's also fundamentally not the purpose of life. I don't, that's a little nothing to do with law, but something to do with beyond it. But making any attempt to solve a problem and assuming that the world would be without any problem, possibly that world may not be, because often I see this, that one of the beauties of the human beings that we are imperfect. Because very soon we would be realizing when there would be lots of robots, there would be complete perfections. Maybe one would be exactly like others. So all I say, no matter how much efforts are there, there would be some mistakes, there would be some problems, there would be some kind of imperfection. Maybe life is all about that. But when Lordship is looking into the rule to test it, whether it is to be declared as a violative of Article 14, then Lordship also draws the very philosophies from the life itself, which has one component of you have to be a good student versus do you have a better skill or not. So if the state, if they have chosen, in my understanding, rightly chosen, but there can be a different possibility also,
that I want to give 2 marks, 4 marks, 5. I'm not using the 10 marks deliberately because it's not directly 10. So I want to recognize and give some weightage to a person who has a skill. Is it fundamentally flawed? My lord, my respectful submission before your lordship would be possibly this is fundamentally, it is possible that when a corrupt institution does so many corruptions, then there is an apprehension that even a good thing they might make it bad. I understand that. I do. I can't talk out of. It's true, but looking from the point of view of the constitutionality and legality, recognizing the experience, which is a skill itself, that itself, now that could have been, I would say, that could have been violative of Article 14 had there been no field for 60 marks in the competitions. I say that what does it make? What is the impact of it? The impact of it, the competition becomes harder for the freshers, meaning thereby, if you are a fresher, you have to be a better candidate. You have to be academically better than a person who was working. So therefore, choice which is being made by the state, that we do recognize the skill, therefore we give an weightage. And because we do this narrowing, we are making it harder, we are getting better candidates. But ultimately, it is 35,000. Even if I don't know how many lakhs, I assume there may be lakhs and lakhs persons. So therefore, only the persons who are better, and within the better, for the timing, within the kindly for the timing, assume that 10 marks is not there. Then what happens? Many of the candidates who had the experience, they will not be able to. Why? Because in that case, this, I would say, this intangible part of it, the educational qualifications is a very tangible one. He got this percentage of marks, very tangible. But the experience, now, if someone asks that you have practiced law for 7 years, 10 years, versus a person who is excellent, he might be first or second in his class, just passed law. What's the difference between these two persons? Well, there are, we recognize, sometimes we may not be able to articulate it, but we really do understand that while dealing with the problems of life, the persons with experience might have some age, which is fundamentally very intangible. And recognition of that age, which is intangible, from a source of persons who have been screened and found to be not tainted, and coupled with others, because of course it's not us, anybody, there may be others also. Mr. Mitro has also said, lordship might definitely say that they have made it is hard competition for the freshers. Yes, they have to 2 marks extra, they have to have 4 marks extra, but still there is a huge avenues for that. That's the reason 20,000 of them, they are there. So if you lordship take it that way, 35,000, so freshers are 20,000, so it's there are huge number. More could have been there. So lordship might see that it is itself is not flawed. Could have been flawed had there not been a 6 times more powerful avenue of written examinations. So therefore, fundamentally the rule, if I can say this way, fundamentally the rule chooses the best person. They are getting the best students from freshers, and they are also getting, I would say, average or lesser best, but with a better skill, which is Also the other aspect of Article 14, that we are recognizing that there is some amount of not equality. Someone having experience of 1 year, 2 years, at least he knows how to handle with students. He knows a couple of things. So therefore, they being not equal, I would say that Article 14 has been translated into reality, and that has been sprayed over and sprinkled in this variety of the schedule. Well, I will make a comparison on 16 and 25 also. Now, my lord, may I go to the rule itself? Well, there are since I was making submission on the rule itself, I thought if I make the submission on the rule, and when I go to the judgment, I will go to the judgment touching upon all these topics. Well, my respectful submission before your lordships on the rule dealing with the point at what stage is that the rule itself is absolutely clear at what stage, and that stage is before interview. And why do I say it is before interview? That's the my answer. First, I say that in every rule there are definitions, rule or in the act, and there are substantive provisions which operate, and there are schedules which are for more minute details how that operation will take place. Here also there is a definitions which is there, I would say they are banking on the writ petitioners. But there are substantive part. First, may I, the definition, Lordship would first kindly see that starts 2-1. In these rules, unless the context otherwise requires, there are judgments, I shall be giving it later on. So therefore, the very definition clause begins with the understanding of flexibility of the definition itself to say that do not read the definitions in contradictions unless that context requires so. I give you a definition, but that is not an watertight. It is flexibility and it has to be in sync with the context. With that 2-1 broad head, now comes 2K and 2L. First 2K, interview list. Interview list in respect of the SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview. So kindly mark for oral interview and lecture demonstration, not post, category wise on the basis of preliminary merit score, that is score from a written test. In this case, state is not relevant, and academic score in the ratio of 1.6:1. That is for 160, 100 of final vacancies. So this is the definition of the interview list. Well, it doesn't really say where to operate, where to be done. Thereafter, this is the merit list, which is the writ petitioners have they have banked on. before my lords, referring to merit list, the substantive part, if your lordships kindly have a look at, lordship will see there is a separate substantive rule for merit list and there is a separate substantive rule for interview list. For interview list, the substantive part is there. Rule 11, sub rule 8. Before reading it, lordship may kindly contrast it with sub rule 16. This deals with the merit list. After interview, Roman 16.
Roman 16, yes.
Yes, I was on rule 11,
Yes.
Roman 16. Because I want to answer first what they have formed. After interview, the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list category wise on the basis of the merit as per Schedule 2. The merit list shall contain the names of all. So therefore, under the substantive portion of the rule, there is a specific portion where merit list has been used, that is Roman 16. Whereas, kindly see, my lord, Roman 8. The Central Commission shall prepare and publish in its website a preliminary list with details of the candidates to be called for interview. So therefore, it is for interview clear, subject to verification of credentials, not relevant, and eligibility category wise. On the basis of preliminary merit score, I could have understood it is ended here, but no. As defined in Rule 2(1)k, kindly, my lord, kindly see the absence of k. The absence of k is there. Sorry, I just, absence of L is there. Sorry. I was, the expression of your lordship, I often, my lord, I do say, words are most of the times not the thing itself, it carries what is something, I don't know whether should I use the word inside or. So when even in our conversations, we know every little and our whole system understands. I understood that I was making a mistake from lordships. So L is not there. So absence of L, what is to be done, what list to be prepared for interview, the rule itself is clear.
Yes.
I would say this way. Absence of L justifies presence of L in Roman 16. And that makes it clear that Schedule 2, now lordship kindly come to Schedule 2 sequence. So that's the entire context and objects ought to be achieved. That the substantive portion of the rule refers the interview preliminary list only. It doesn't refer about the merit. And then the sequence part lordship gets it in Schedule 2. Well, Schedule 2, to my understanding, the sequence is so clear that it says, I would say, kindly look at the first, the number. Number 1 is the written examination. So that's the area where one has to be the best. 6 times powerful, as I said. And number 2, that's the number, academics, has 2 components. It's a small a and small b. The small a has 3 buckets, which can also be said to be arbitrary. Somebody can say that I am getting 80, so therefore 60 plus and even 100 are in the same bucket. It's possible. So that's why I made a comparison that prior teaching, that is more granular. This is more compartments are there. But Lordship may also consider that if we call it arbitrary, I don't want to call it arbitrary. If we philosophically, not legal arbitrary, if we call it arbitrary, but there is always a point which can be said to be arbitrary. If Lordship draws from life itself, which is the part and parcel of the law, that I do believe, then somewhere there has to be a full stop. Somewhere there has to be some kind of collateral damage which may not have any legal right, which has to be accepted. There may not be a law which would address for every individual variety circumstances. Somewhere has to be, but effort has to be made. Is it so wrong? Or no, some efforts have been made. For an example, for educational qualification, I would look at it is fair enough. Yes, could have been even the 5 buckets. I don't mind it. But I would say that it doesn't make you of that kind of candidate that who would say that it makes that competition level of 60 marks becomes harder. Yes, it puts you with some others in the same bucket because it is only 3 buckets, not a 5 or not a 6. But still, if you feel that because your educational qualification was better, you are a better person, compete better, become a better student actually in the examination itself. That scope is there. Therefore, existence of that scope, which is same for everyone, neutralizes quote and unquote arbitrary. Can I resume?
Yes, it's nearly 30.
Yeah, that's what I'm saying. So, it's 30.
One.
No, but it's a 30.
Yeah, it's 30.
What? Yes.
When to resume is the question mark.
Saturday.
Don't block the court. You all may come. It's absolutely difficult now.
And my lord already in Panchayat
No, no,
matter
Smith,
going on.
no,
My
that-
lord already had that matter a whole day.
Well, I have always opposed to Saturday courts because Saturdays and Sundays are the busiest for us.
True.
Busiest for it.
But
Not
we
easy.
need. I am a believer of. I don't believe that this theory of doing everything. It makes a person ultimately at some point very troublesome. So we should take rest. Lordships should also take rest.
The mind should rest.
You need your mind to at least recover,
Absolutely.
to repair,
Absolutely.
to learn, unlearn, relearn.
That's why our holidays are
So,
very
extremely.
It does.
that the common public doesn't realize that. Even the government says that we should be working 365 days. We are not machines.
Yes, we are not.
You read a draft, you leave it aside for 2 days, you read it all over again, and you see so many flaws over there.
Malad, in argument, our finest arguments come in course of arguments.
Yes.
Absolutely.
It is in the
At the time of preparation,
it
it
in the
doesn't come.
interaction. That's I think
This is
most
what is experience.
yes.
And that is why 10 marks is required.
He
That is
make
true.
out his case file.
No, not next. Look, we are ultimately, my lord, dealing with raw life. That's good that we don't want to be touched because then we will have an emotional breakdown. So we have to say law. I mean, it's a law, but ultimately, my lord, it touches upon this. That whatever our understanding, those are in a different package. We call it law and differently so that good remains better.
সেটা একবার জিজ্ঞেস করে দাও। দাদা আর কতক্ষণ লাগবে?
Tuesday.
How many are there this side so that I can start with the rest?
Sandal is there. I will take not more than 15 minutes. I assure your lordship.
Because more or less all points are being
Yes, that's
covered.
exactly why, my lord, I will not take more than 15.
The Sanyal, where is he?
He is not present at all.
Not here. How long is he likely to take? Any idea?
Not yet, perhaps 30 minutes, because the judgment part has already been cited by Mr. Mitro. So he will only argue on the rules according to whatever instruction I have been received from Mr. Shandal.
Mr. Mitra and Mr. Dhar have covered roughly every
Also,
just a few
judgment.
bits and bits here and there, and that's about it.
Well, may I make a very humble prayer, because there are some cans. What happens that they filed it, it is there. Lordship
Not
kindly
in the
also.
list.
No, it is in the list itself.
Formal order is required to be passed
The-
for addition.
All AORs are also there. We are so
Yes.
they have to also.
Addition.
Yes, only addition.
All right.
And another
Item 14, can
7.
Can 7.
Lord, my can, your lordship has added me, but it's not showing in the list.
That is the reason.
add করে দিয়েছে বলে দেখাচ্ছে।
Added this post. It's not there in the list.
Yeah, that's okay, because
The files.
We have been added as parties.
So I even made that.
once you are added to, you are
All your files are there.
the
All your files are here. Your opposition, you all can come up with. The additions, formal additions will be made.
Whatever is on record on the basis of that itself.
Yes, yes, yes.
For my understanding, whether an advocate on record add by own.
No, no, the department will add.
that direction was there.
Step. But since the files are here, possibly the formal addition has not been done. The files are required to be sent to the department. Then only they can add it. Right?
Actually grateful for that.
Yes, yes. Not you. It is the department who will do. Don't take it on your shoulder.
Yes, yes.
তুই সবকিছুই নিজের উপর
HUD submission made on behalf of the. Which application is yours?
Well, this is
Item 14.
submission I made in item 13, and this time for addition I am seeking item 14, can 7.
I am in item 10
Lordship is putting everything in
all together, but then
because it's not separate.
I have not made any order with all the
Well, one
numbers
application,
together.
Kindly, because one applications, Lordship kindly also understand the AOS. They have to. This application is pending, so as if nothing is happening. So
No, no, I'll add them.
Nah,
I'll add them. But then in 10, you are not there.
no, I am there in Rahul 13, 14,
13.
12. I am 12 in 12 there.
All right.
10.
10, you are there. Application number.
Can 1.
Acha, HUD submissions. Now, learned senior counsel concludes the submission. Senior counsel of the applicant in can 1 concludes submission. ঠিক আছে? Released for further argument on blank. 11. Any applicants?
No.
নেই তো? It will remain in the list. 12, you are there.
Yes, I'm there.
Which application?
No, 12 application already allowed.
Allowed. All right.
12, Lordship may record that I have filed the opposition to the.
12.
Yes.
All right. 12 affidavit in opposition filed by the added respondent.
Either.
Under the back sheet of Sakhawat Khandakar is taken on record. It will be open for the petitioner to file exception to the same. List for further hearing on blank. যে ডেটটা দেবো সেটা সবার জন্যই যাবে। 13.
Same order.
Well, can 5 allowed?
Can 5 has been allowed.
Same order.
List for hearing on. List for further hearing on. 14.
14, my lord, 14 only I am seeking. There
Can
is a can,
7.
can 7.
Can 7. Can আগের order আছে আপনি দেখে নেবেন. Can 7 is allowed. Department to make the necessary addition in the cause title of the writ petition. Stop. It will be open for the applicant to file affidavit in opposition. 15.
15, I am for the petitioner. Well,
Yes.
the can has been early added, but no opposition has been filed.
You want to file, you file it
No,
because
no, I am
there
the
is-
petitioner. Well, the can.
oh, you are the petitioner. Then the direction for opposition is possibly there.
No, this is matter is different.
Different.
Because, yes, well, the double benefit. Well, the 9.
Yes, 9-10 experience
That's
cannot
not
be.
but a senior friend also appearing in this matter.
Yes.
ওটা তো আছে,
So we'll take it up separately. 15.
No, no, this is the matter is going on. Then, but they are want to file the opposition, then they file it.
If they want to file, they can file it. No difficulty. But then no order is being passed in 15 now. 16. All these 16 and thereafter no order is passed. No addition of party is also there.
There is one 18 there opposition kindly.
18 mile we have an application.
That was already allowed, only opposition.
Anybody filing it today?
Yes, yes, yes.
Oh, ligan in item 18. Which applicant?
Well,
There, I
application-
can see 4. None has been allowed possibly.
No, in 18 allowed.
18 opposition.
No, no. 18 it was allowed. I was can 2.
And can 1, 3 and 4 is anybody there in item?
Can 3, can 3,
Yours.
yes,
All application for addition of party?
yes.
All the 4 cans in item 18 is allowed. Formal order করবেন কিন্তু আর অপোজিশনের ডিরেকশনটাও দিয়ে দেবেন
এই মৌসুমীতে ক্যানটা এলাও হয়েছে
after 18 no other matter.
23. 23 there is, but I am not confident about.
Moshumi Monda remember that matter goes up to Supreme Court. Supreme Court order it is mentioned.
23.
In 23 well, we have filed an application.
I not get here the copy.
Copy all copies to be circulated, please. Item 23 record an order. Opposition by the applicant under the back sheet of such and such. কোন অ্যাপ্লিকেশন উপর লেখা থাকলে ভালো, না হলে ব্যাকশিটটা দেখে করে দেবেন। ঠিক আছে, যেটা যার যাতে সেটাতেই যায়। টেক কেয়ার। ঠিক আছে, আচ্ছা
সেই না 21
23 হ্যাঁ রিপ্লাই
But there is one can 1 that needs to be allowed.
23.
Yes.
Yes. All cans allowed. 23 cans allowed. No further. ঠিক আছে?
Deeply
Your Lordship's query was, my lord, in 2016 rules whether the segregation of marks for academic qualification was there or not. It was there.
It was? All right.
It has been annexed in item number 10 also, my lord, page 350.
A chart.
I'll prepare a chart.
Difference.
Yes.
Annex the 2016.
No, a comparative chart.
Well, I will do that. I will do.
Yes.
But it chart in the petition itself.
All right. When do I fix it?
Which day?
Monday.
So don't block the Monday.
No, Monday. Don't do. Monday. Let us also do some other.
Y'all, yes, exactly. Y'all also have other matters.
Yes, but I'm saying.
Do not keep yourself blocked over here.
Twist it,
Number
twist
17, my lord, remember that QWS matter.
Let us finish this matter first.
Yes, when do we keep it?
Tuesday.
Tuesday. 9. The AG is sitting behind. I cannot see him. I do not know whether you'll get a chance on Tuesday or not. All right.
That I can
Then the commission is also there. Commission is to be heard. Tuesday 9. সবগুলোতেই 9th করবে।
In that 17. The validity of substitution beyond the last card because verification is.
Yes.
Then I'm
Tomorrow? Tomorrow means the next working day, Monday. All right, all right.
Otherwise,
17 নম্বরটাকে সোমবার দিন, কারণ অন্যগুলো তো 9 তারিখে হয়ে যাচ্ছে, তার মানে ওটা আগে উঠে come up.
So may I be permitted, my lord?
I am praying for a kind leave, my lord, to move a very urgent unlisted matter. My lord, if your lordship directs me, I can come to my lords. Upon service also, in the school service commission matter, written test, I appeared, qualified. My name appears in list number 2, serial number. Now, when the interview is going to be held, my candidature seems to be rejected on the ground of overage. While in SLST 2016, I appeared, my name did not appear in the.
Is this the teacher recruitment or the non-teaching staff?
No, teacher recruitment.
Teacher recruitment.
In commerce, I am MCom. Now.
Very well. Please serve and come back. Commission, if you are there. 1 minute. That way you cannot do it. Just wait. Tuesday. What same? Huh? On the ground of overage.
MS verification where there is a 45 marks will be the qualified number in 2025.
All service to be made upon the commission. The learned advocate is over here. You can serve him.
Kindly kind leave.
Is it affirmed copy?
It has been.
If it is, take back the copy, affirm it, and then come.
I will be there.
Yes.
Yes, yes, affirmed.
Result of which we and other things are all installed. That being the situation, Lordship was kind enough to allow this matter and to direct my lord listed at the beginning. It was not listed because our fault also because record was expired. Now my lord it is listed item number 2 for only difficulty my lord 2,500 students or the non-cooperation of the president who happens to be my lord a very influential person of the locality. But the school authority is not going to see that my lord is pass and all other things. That should not. That being the situation.
Now what is to be done? You see the condition of the list.
It's going to be suffered.
Yes.
A small mallet, the 5-10 minutes is required.
5-10 minutes. I am here every day.
True, mallet, but the things you kindly consider the plight of the student. Man. Midday meal is essential for the village person is concerned. And
15th it will appear. 15th.
May I permit it to mention?
SSC matter, madam. Running in the monthly stats item serial number 1667.
What is the issue?
We are the state aided college teachers.
See, the issue is pending consideration. Whatever order is passed will cover you. Do not worry about that. Just wait and watch what happens.
In the head of SSC.
Give the number SLST.
May I permit?
In preliminary interview list, my name featured as serial number 8. I secured 71 marks, 10 marks for prior. Now they have published this from second December 2025, disqualified me, reducing my prior experience to 0 minor. I have already annexed everything. I have made objection on the same date. Until unless the matter is not adopted,
it cannot be helped, sir. It just cannot be helped. I understand, but the way it doesn't matter. The main issue is pending consideration. Or
I mentioned the same in the application form.
Despite awarding after credential verification, if they get to see that you are not entitled to the marks, they are taking it away. So it cannot be said that they are doing anything wrong. Nothing. File it in the department. Yes, sir.
Was a teacher of RB Public School. He worked for 2 contracts.
What do you want?
The inclusion of the matter. I did.
Inclusion, no inclusion.
I'm praying leave move a matter upon urgent basis. The petitioner had.
Where is the matter?
My lord,
you want leave?
Yes, my lord.
Why?
The petitioners, my lord, had applied in a second SLST exam under my lord SC/ST category, but their category has been wrongly updated into general one. The verification process is going on, and some of them, my lord, maybe matches the cutoff of the verification. They'll be highly prejudiced, my lord, and the court has passed the identical order regarding such, my lord.
All right.
Grateful, my lord.
Tuesday.
Here, my lord.
Is it an affirmed copy?
My lord.
Here, my lord, I have also same matter, but my lord, it is Jalpaiguri bench, my lord, circuit bench.
Go to Jalpaiguri.
My lord,
Bench is not there.
no, my lord. Now the bench is not there. May I have a leave, my lord? I'm my lord,
when will
fully
the-
covered by your lordship order.
When next week also the bench will not be there? In that Tuesday. Leave দিতে হবে. This is a Jalpaiguri matter.
Yeah, affirm করে আনবো।
Is it not affirmed?
I will come back with that.
Yes.
My lord, may I permit to mention monthly list 1560 for upgradation. That is in respect of die in harness writ petition, my lord.
Died in harness, what you want?
My lord, for the order passed by the DI, that against that the writ has been filed. Only for upgradation.
Challenging what?
Challenging the order of DI for rejection of my
Claim. Claim for what?
For my that is in respect of die in harness. My application has been rejected by the.
Pension, retirement dues, compassionate appointment.
No.
Many things. What?
Compassionate count.
Compassionate appointment.
Yes.
It has been rejected.
Yes.
Please wait. No upgradation.
May I permitted to mention for correction or
Correction?
Yes.
What?
order?
What is the correction? Yes, madam.
Updation, Lordship.
Why?
Second SLST matter, question dispute matter, Lordship. Similar matter already running in the list, Lordship.
Already running. Second SLST bundle দিয়ে দেবেন তো. Give the number.
Order has been passed by the Lordship. Order, Lordship.
Well, I do not want to see. What you want, you say. What you want, madam, please say. Yes, what can be done? Yes, please say, make your submission. What you want? Contempt you have filed. Yes, it will appear. Do not mention. Yes, sir. No inclusion, sir. Why?
The matter is very urgent. It is about wrongful evaluation by TBS. And petitioner prayed for implementation of our latest 2025 decision passed by Honorable Supreme Court, which allows exposure of other candidates' marks. Petitioner only seeks enforcement of his classmates' marks, so that to ascertain whether there had been a fair evaluation.
All right. There is no urgency to let him appear. It is his marks. He will not see how much others have got for the other job interviews. I will see what is to be done. Not now.
Should be permitted to mention for upgradation in this matter. This matter is appearing in the monthly list of December 1152. And this matter is about to, in this petitioners, prayed for release the retirement due. And lastly, this matter was appeared in the 2nd of May. And after that, it is not coming up in the list.
Please wait. Yes.
Lordship, in para 4, it was written typography written. It was a preliminary interview. The documents verification is under process.
I cannot hear you.
Due to some typographical error.
What is the typographical error?
It was written in the order that is preliminary interview. My prayer is that documents verification is under process, my lord. So for that it was.
Give it for check it up. If there is any error, then put it in the correction head.
Grateful, my.
Your name is not there. When is the matter appearing in next? Fixed on? It's not there in the order? It must be there when it is returnable. If it is there, the returnable date, then last, you do not.
The petition has been dismissed. Disposed of.
Oh, it has been disposed of. Dismissed. Take their appearances have not gone down.
Sorry, there was an order which had been original site original site was passed in August.
asking us to reconsider, we are the insurance company, reconsider such representation. We had filed an application for modification of that order. Dismissed that modification application, but indicated that all matters are open for the insurance company to consider when the representations are being considered. Now we have given them, thereafter we have given them notice to appear for hearing. Prior to the date of hearing, that which was yesterday, they did not appear. They have been issuing us letters after letter for content.
What do you want the court to do?
Well, it's a disposed of proceeding.
What you want the court to do?
Is that continuously we are being sent notices with regard to contempt.
So what?
Well, because they have not complied with the order. Lordship passed an order in August. Lordship asked them to give a hearing.
Call the list, please. I'm
Great,
not hearing
great.
anything.
Yes, Miller want with liberty, Miller, to move afresh on
Why?
updated course of action.
2017 matter, now you want
It was
non-prosecution?
happened only there was direction for affidavits. What happened?
Yes.
This is regarding, Miller, the approval of appointment of the petitioner in the post of computer teacher. Now, Miller, this matter was moved, Miller, not from our chamber. Now, Miller, subsequently, there are several schemes has been laid down by the district inspector of schools for some giving benefits to the computer teachers. Now, the petitioner's appointment was not again a sanctioned post. So that is why he wants to withdraw this writ petition with better particulars for that scheme, for getting benefit of the scheme under
Then
the
what is the use of granting leave? If you don't want to press, don't press. If you got a fresh cause of action, file a fresh petition.
Yes, with liberty to move on fresh cause of action. Justice kindly.
That liberty is not required.
Not
You
required.
are always free to come up with. Please come.
Original.
Pradeep, not press. Please pass orders. And the written communication, if there is any, please keep it.
There was no interim order.
Yes. Correction.
Last liberty to move on a fresh cause of action, if that is added, my lord. My lord, we do not know once a petition is moved, then again a petition may be on other cause of action. So, my lord, a different cause of action we shall move.
Different cause of action. Why is leave required, you say?
My lord, nowadays so many embargoes up. Only
there's a different cause of action.
Yes, is kindly mention if anything of these. That means the equal pay for equal work prayer is also here. If we have to add this below, that is why. Is kindly add.
Leave is required only if the self-same cause of action is there. If there is a fresh cause of action, there is no leave required.
Under the scheme, but if we pray for the equal, pray for equal work, which is also prayer in this writ petition. So, Miller, coupled with 2-3 prayers. So, if one prayer is covered by this writ, Miller, yes. Miller liberty, Miller losses kindly give.
Let me see your letter. Notice the not press. What letter has your client given you? How you have advised your client, I do not know. I don't want to proceed for my personal difficulty.
Yes, my lord. Thereafter, now prayed for liberty.
That you have added.
No, not added. My lord, that was our advice that if we want to.
So that means you are not giving proper advice to your client. If you have got at least a part cause of action there, then you can proceed with the matter. You can fresh cause of action. You can file fresh petition. Why you want the whole thing pending from 23? It's at a matured stage. You want this to be withdrawn, go back afresh to square one, and then you start. I cannot follow. So leave I cannot grant. If there is fresh cause of action, it's all right. Item 2, what is the correction?
But in this matter, my lord, the objection was made only to in the Siliguri matter, my lord.
Oh, this is a matter of Kuch Bihar.
Kuch Bihar, my lord.
How can this be taken up here?
My lord, liberty to move this bench.
Send it.
My lord.
এটা কি ঝামেলা আছে?
It
We
sent
can
it,
send it.
my lord.
It will be renumbered and it will go.
Or if he can file a press release.
Party right.
Correction. Item 3, what is the correction? Item number 3, somebody's appearance has not gone down or what? Why is it appearing for correction?